80 of the hearing list, that is against the criminal appeal against the vigilance department. 8 years since the petitioner is out of service, my lord, because of this pendency. Your lordship may kindly add your take up the matter any day. Your lordship feels convenient.
Today also it can be possible. Wait, let us see how I am proceeding.
If it is not there, your lordship may fix up it.
Pardon to mention that I appear for a cab company named Hon'Ble Cab. I had a subsisting agreement with a local cab agency here. A dispute with regard to non-payment of some dues had actually cropped up. An FIR was registered. I had challenged, and then meanwhile the parties are settled. There is a settlement agreement also drawn. I have paid all the bills. The lordship can list.
This is a CBI case.
No. It's a normal case registered.
Okay.
Yes. Tomorrow.
Beg pardon, my
Not
lord.
tomorrow. We'll give it.
Monday.
Beg pardon, my lord. This is a petition under section 1482 CRPC for quashing a proceeding under section 138 NI Act. My lord, this is a case pending since 2017. Only after initial the complainant doesn't attend the court.
You should be happy. Why? If you ask for quashing, I'll issue notice, then complainant will come.
Honestly,
And he will be in trouble.
yes, let him come. Honestly, I'm.
And the complainant is not taking care of his own case.
Because he knows that it is a false case, he doesn't appear.
The petitioner is the one. Mother-in-law has filed a DV case in the normal court. But the petitioner has been deserted by her husband and in-laws since 2013 and residing with her family members.
So what do you want?
This case may be listed now.
Okay, listing.
Partly
you have argued also.
Arising out of employees compensation and death case, my lord, kindly listed appeal of the year 2023, my lord, ready for hearing. Ready for hearing.
First appeal.
My lord, ready for hearing. I have two efforts, my lord. Earlier I have also filed two memos, but not listed. Even specifically, your lordship allowed memo to list the matter, but not listed. I have also verified the. I am also not going to the section, my lord.
Settle the dispute or
settled by it can be settled. Can be settled.
Yes.
May I be permitted to mention, my lord? Memo may be directed to be sent to the list, my lord. It is not going to the section, my lord.
No. All the memos we check it and thereafter priority wise we send it. It will go definitely.
Can be settled. May I be permitted to mention, my lord? This is the I am for wife, my lord. The out of matrimonial dispute and criminal revisions in filed only because this was specifically urgent to list the 22nd, but could not be listed, for which the husband is not paying this is the maintenance. That's why it is very precarious. This will be listed.
Take it, maintenance.
Pardon, my lord, bail application tied up matter, my lord.
Bail applications today also I have listed about
My lord.
30-40 matters.
Item 78.
Out of list, if you want to any mentioning, otherwise let us see.
Can you mention item 1 to 4?
Well, item 4, my lord. Can take one capital.
Yes, again, 4, yes, 3. Yes,
3, my lord. Item 3.
3. Yes, not 4.
3, my lord.
Okay, 3, 4.
My lordship, item 1, can it be taken some other day?
No, one is that done, interim orders may be passed. Because now the trial court is insisting upon continuing the trial. So let an interim order.
I'll adjourn it, let them move application.
Yes, my lordship.
Adjourn it on request of the counsel for ED. Since the matter is proceeding before trial court, liberty is granted to the petitioner to move application for adjournment owing to the fact that the matter is already before the
both trial court as well as the appellate authority in the proceedings confiscation.
Courts below court, no? Courts, the plural court. Yes.
And urgent copy.
Yes.
5 to 17.
My lord, item number 6. 2 weeks after, my lord.
2 weeks after.
Item 18 to 28. 29 to 36. 37 to 39. 40 and 41. 42 to 48. 49 to 52. 53 to 59.
60 to 66. 67 to 75.
68 miles. 68. On the road, Mr. Mishra, for day after tomorrow.
I am simply urgent, but day after tomorrow, not you. Urgent. Oh, 2017 matter.
Day after tomorrow, tomorrow.
And you know that because I am not sitting for you only. 2017 matter, you have taken the stay. Now tomorrow, day after tomorrow, midnight and all these things will not work. I have to let it be there. I'll impose cost and adjourn it. You have taken 2007 interim orders are there. And you know that day after tomorrow I can't take it up. So that is the ploy you employ.
Today, Mr. Mishra,
Maybe, but you pay a little bit cost to the bar, enrich the bar and enjoy the stay. Yes.
Item 74. And if you want it after the entry one is there, continue.
70?
4.
2024 matter. 22.
Entry one.
Yes.
76 and 77. 78 to 85.
78 in fact. The compromise matter. Both the parties are available. You have taken at 12.
What are the offenses?
490.
Okay. 12 o'clock, you come.
86.
Stop.
Item 2.
Master orally instructed him to include the 144 proceeding, my lord. He has not included the other party.
Not included.
Your lordship is verbally instructed to include him, otherwise have maintenance. Not included yet.
For the password, then I'll dispose it up. Okay. Password one.
Item 4.
Yes, sir.
Petitioners. Here, my lord, tasseling the order of petty cognizance dated 1/6/2024. I filed this for its application. My lord, here I have annexed the FR. If my lordship will go through the same, running page 14.
Yes.
It is admitted in the FR also in the 1/6 statement that there was some power of attorney executed by the informant in favor of the present petitioners. And he had taken a total amount of rupees 61 lakhs out of 1 crore and 60 lakhs. So, as because I failed to pay the amount, can it be attributed section 420, my lord?
No.
It is a civil nature.
Maybe.
So that is why I have
taken the
said
money.
this. Once there is some power of attorney, and by virtue of the power of attorney, I have to say.
Let us see the charge sheet.
Yes, my charge.
Very charge sheet.
Charge sheet is cognizance order is there.
Charge sheet, show me the charge sheet. What are the allegations? You have not filed.
Charge sheet I have filed the order.
Charge sheet is required. You are challenging cognizance order. Right on. The petitioner is challenging the order dated 1/6/2024, passed by the JMFC COG 1, Bhubaneswar NCT case number 313 of 2024, whereby cognizance of offences punishable under section so and so has been taken against the petitioner. However, in the petition, the copy of the charge sheet has not been placed. Therefore, release the matter after 3 weeks. Yes, please.
Well, in the course of that, I am serving.
3 weeks, sir.
Charge sheet.
Yes.
My lord, I may be excused. Last time, perhaps charge sheet was submitted. I may be excused if I am wrong.
I don't know whether you filed or not. You said no. That number I didn't know. You filed it.
My lord.
You should know that whether you filed or not. You filed it by way of a memo. Yes, come to the come to the charge sheet now. Come to the charge sheet. Yes. Somendra Mahapatra, Gauri Hari.
Gauri Hari Rana Singh.
Come to the charge sheet. What are the allegations? Yes. Do you have the copy?
My lord,
Just see.
my lord, charge sheet, from the brief fact of the case, my lord, I will placing. During the course of investigation, examine the complainant witnesses who are proved the occurrence, recorded their statements, photocopies as such, and the general power of attorney given by the complainant in the name of the director, SG Infrastructure, that is my company, my lord. Agreement for sale done between Pavitra Kumar Mahapatra and Somendra Mahapatra, and the agreement for sale on 18/6/2012.
There was a condition that you can't do it without making final payment. Yes.
So no, if this honorable court will accept the investigation part, that I have paid the amount, but some dues are there. So how it is amounts to cheating?
Prima facie case is, madam.
Cheating, my lord, it cannot be treated as cheating. It is civil nature. It is a breach of contract between the complainant
Civil,
and the
it
accused.
may be a case of civil nature, but their criminal facet is also involved.
Well, recent decisions
Involved.
are, my lord.
Recent facts, just see the facts.
Yes, here exactly that fact is there, my lord.
What recent judgment? So,
But recent decision is similar. I paid, partly paid, and thereafter a recent decision.
which paragraph? Which paragraph? Which paragraph?
Last part, pakra copy ne gotte copy ଅଛି, my lord. Last part 2 paras.
Merely it said that it is a civil dispute has no criminal. Where is the facts? Resembling to the facts
Yes.
of this case.
Very beginning it has been mentioned that there is contact between those.
No. This is a commercial transaction and there is money. Here the land dispute, you have a power of attorney is there.
Here is also land
And
dispute.
You all, builders and all these things. Cognisance says I can't.
No, my lord. My lord, now kindly see the running page in this petition. Running page, that is annexure 4.
Yes.
With
Four.
regards to that self-same property, which he has executed power of attorney in my favor, the property owner has filed a case against him.
And all these things are,
That how you have executed power of attorney in favor of me. So it is completely civil nature. Civil dispute is pending.
Yes, anything? Yes, sir.
That is running page annexure 4, my lord.
Okay, I'll pass the order. Yes. You will start of them. I'll pass it. Yes. Next.
Lords, here I am aggrieved by an order at page 12 of the brief.
12, 1, 2.
My lords. The latter part of the order, your lords, you may see the order begins letter dated by 22/7/24. This order arises out of a
This is
petition.
22/7/24 order.
Aye.
Yes.
Order arises out of a petition filed by learned counsel for accused for a direction to the Superintendent Special Judge Harpada to produce duty register of jail staff from 119 to 411-9, copy served heard. Then the court side, learned counsel submitted that during course of evidence, witness Subhankar PW2, Santanu PW8, Dharanidhar PW9, and Harisankar PW31 have deposed before the court as eyewitness to the occurrence. He further submitted that the witnesses were inside the jail premises on the date of incident, but in fact they were not at all in duty on the relevant dates and prayed for directing superintendent to produce the duty register.
Reversal alibi. The
No.
witnesses were not there.
It's not alibi, my lord.
Yeah.
I am submitting like this. Your lordship may kindly please look at.
You say that the witnesses who deposed against you, they were not there.
Yes.
They were in jail.
They were inside the jail. Incident has happened outside the jail. My lords may kindly look at page 14 for a moment.
14, yes.
This is the FIR, my lords. At page 15, your lordship may kindly see who are the accused, column 7. Unknown persons.
Yes.
The informant is one of these witnesses, Sibo Sankar Mishra.
He was in custody.
Yes. No, he's a jail staff who has deposed as an eyewitness. He is the informant. He files the FIR, my lords, saying like this.
Is it a jail offense?
Yes, what has happened is a warder was killed in Bhubaneswar jail. And in connection with that, this affair has been registered.
Then the witnesses will be there in jail only.
Yes.
If incident had taken
Yes,
place.
but the murder took place outside the jail premises. All these witnesses are jail staff who were not on duty at that relevant time, and so therefore they could not have seen the occurrence. Even the witness Subhakanta, who is the informant, in his FIR he doesn't name anybody. That's why I have
Where is the
annexed
incident? Let us see the chart.
my lords may look at page 16.
16. Yes.
FIR relating to firing on warder Manas Ranjan Naik on AK-11 during evening hours. I am to inform that one warder, namely Bhagavan Nahak, reported at about 7 p.m. that Manas Ranjan Naik, warder, has been fired while going to the outside barracks. And jail ru bahar ki barracks ku jaut.
While going to.
Jail ru bahar ki barracks ku jaut. The barracks is outside the jail campus. Then he says, warder was going to the barracks situated outside the jail premises on the left side of the main gate, eastern side road of the jail.
Yes.
At about 6 p.m. while I was at my office, one convict, namely Bikram Patra, informed me that Tukku alias Abdul Naim Khan was telling that tomorrow a new jailer will come. There was a dispute during daytime between Tukku alias Abdul Naim and another youthful offender prisoner, for which the entire prisoners of the youthful offenders ward were shifted to ward number such and such. Some unknown persons have attempted to kill the warder, Manas Ranjan Naik, by firing. On this FIR, my lords, now these petitioners and some others, they are facing trial. Now, after the evidence was over, my lords, a petition was filed by me under 340 before the trial court.
Yes.
Now, this petition was filed by me under 340, asking for a preliminary inquiry being conducted with regard to the false evidence adduced by PWs 2, 8, 9 and 31.
Yes, where is that application?
My lords, I am coming to that.
Yes.
Since that petition was rejected, I came up in this court. My lords may kindly now look at page 91 of the brief.
91. Yes.
That is the order in that application.
That 340 application.
Aye. The court writes, criminal appeal has been filed under section 341, challenging order dated 31/7/2023 of learned additional session judge in such and such, rejecting petition under 340 to conduct preliminary inquiry regarding false evidence adduced by PWs 2, 8, 9 and 31. And initiate a criminal proceeding under 195, 120B by 34 IP. Various status report submitted by the trial court indicating that after closure of case from the prosecution, accused statement has been recorded. After closure of defense evidence, case is now posted for argument. Counsel submitted that evidence of the aforesaid 4 witnesses would itself indicate that they are in fact not eyewitnesses and they have adduced false evidence before the trial court. And there are some material documents available on the record itself which can substantiate
Next
the
paragraph, needless to say.
Yes, needless to say, when case is posted for argument, if learned defense counsel argues regarding non-acceptability of the evidence of the aforesaid 4 witnesses as eyewitnesses to the occurrence, trial court will deal with the same in accordance
That
with
is there. That is always
Yes.
there.
Now, thereafter, my lords, this order has been passed at Annexure 1. What does the trial court say? Kindly look at that order at page 12 again.
You move another application.
Yes, I moved an application that
No,
let
but this court says that at the final argument you have the liberty to do
My
that.
lords, it is at the final argument stage that I moved the application.
But you have to argue it, not that you move application.
What will I argue? Unless the document comes on record, how will my
And
argument be
eventually what you want is, now you want to lead evidence in defense. Intrusion.
I want to establish, my lords, that these 4 witnesses have deposed false.
No, I just want to overcome the order of this court, where
This
you
court-
moved application 341 and it was turned down and
This
said that
court-
you argue that at the final
No,
stage.
this court never turned down my application. This court simply said that I am to move the trial court. My lords, may kindly look at the last paragraph of this court's order,
Yes,
93.
needless to say.
No, thereafter, my lords. If any material document stated to be available on record and defense wants to prove the same in accordance with law and files a petition to
Okay,
that effect,
okay, thereafter you file.
after hearing the other side, necessary orders can be
Okay,
passed. by the
thereafter,
trial.
okay. I just-
Now what he writes at page 13, my lord Smith.
Yeah, what do you say?
My lord, here is a case, my lord. your lordship-
And the court has given liberty to move application. He has moved the application. The fact remains that whether these 4 witnesses were there in the spot or not, that's the question. The incident has taken place outside. They were inside. And all these things,
And
have to be.
there, in the, my lord, in the jail premises, there are some orders are also moving out.
Hey, what is the prejudice caused to the prosecution by producing these documents? He's not asking anything. Produce the document, let it be decided.
Again, my lord, reopen that will be reopened.
No, he only says that, see, what is he asking? Show me your application, which you have moved.
I have moved for production of the duty register of the jail.
Production only.
In the order, your lordships may kindly see paragraph 30.
Yes.
If the documents will come, my lord, then that should be called in evidence. Then who will prove that, my lord? If the person who has already, my lord, will produce before the court, he will again I will, so it will amount to the reopen of the case, my lord.
No, it's not reopening.
Page 13, your lordships may kindly.
Yes.
On perusal of the case, it reveals that it is a case under section so and so. Arms Act 36 number of witnesses have been examined from the side of the prosecution, and now the case is pending for argument. Though the witnesses have deposed as eyewitnesses, but whether they were inside the jail premises or have seen the occurrence can be ascertained after appreciating the entire evidence at the time of final decision of the case. The evidence from both the sides have been concluded since long, and now the case is pending.
Who is maintaining the register? Who is maintaining the register?
Jail authorities.
Who? Some must be, some clerk or somebody must be doing it. He can bring in, produce it.
Or take instruction from other things.
As simple as that, because it's a murder case.
Madam,
And this court has given that liberty.
This is a case of the year, losses, several cases have been filed.
So therefore,
what are that petition?
therefore, see, ultimately, what is the trial? To find out the truth.
Exactly.
And in the month of 7 July, this order has been passed. Now we are in February. But the case is at the.
I'll put it next week. You get instruction. See, this much only. The document will be brought by a clerk and produced before the court. And through him, it can be exhibited. He is the person who carries. These are documents only. No oral evidence is required.
Yes.
He will bring it, and the court will look into it and decide it.
Fine.
This way or that way.
Next week, any day.
And that is the observation made by this court earlier. Okay, next Tuesday. Issue notice. Accept notice. Please give at 12th. And finish. Instead of delaying it, it's better that a clerk should bring
Exactly.
and give it and
Yes.
let the court decide.
Let him undertake that, except that he will not examine another.
Undertake what? How can you
That's
undertake?
if he has a right, he has a right.
How silly.
Either he can concede, or I can say.
How can counsel?
But see, the application is a production of a document.
Exactly.
Document can be produced by the clerk.
Yes.
He need not be cross-examined or anything of that sort. He has to get the document, place it. That's all.
Thereafter, my lord.
It is not a 311 application. Remember, he's not moving up 300 for recalling some witness.
Thereafter, my lord.
Sometimes when learned counsel becomes counsel for the state,
My lord,
they believe that they'll be permanently on the other side.
Thereafter, 311 will come, my lord.
Let us.
For proof of that record.
Okay.
May I please your lordship? My lord, it is a matter, the petition number 1 in the opinion number 2. at the husband and wife, my lord, and the matter has been settled by annexed to your lordship, may kindly say.
What are the allegations, sir?
Allegation, my lord, 498A
Okay. Issue
and the
notice,
others,
sir.
sir.
Issue notice to respondent.
My lord, I fail this case, my lord, for A.
Let us go. Where item 7, na? 7?
Yes, item 7.
Okay. Where have you said that a compromise? Huh? The parties they have compromised. They filed, parties have petitioners are na? Petitioners are accused in so and so case. The dispute is arising out of matrimonial discord. Parties have entered into a settlement. A compromise petition signed by both the parties has been placed on record as an except to the petition. Issue notice to opposite party number so and so. In the meantime, proceeding before so and so. What is going on? Where is the proceeding?
Proceeding, my lord, charge sheet has not been filed.
Then what can I do? What will happen? What is interim order? Issue notice only.
Yes, notice.
Yes.
Obliged.
Item 8.
Yes.
May I please, lordship? My respectful submission here is that in spite of the abolition of triple talaq, the husband of the petitioner gave talaq to her, and in this respect, the petitioner lodged FIR before local police station. Still then, the local police did not arrest the petitioner arrest the husband in accordance with law. Lordship, may kindly have a glance. Annexure 7, page 33.
You have implemented all the officers of state of Orissa, except your husband.
Except my husband, because it is a
You implead him.
inaction of the police. Police did not entertain the FIR properly, my lord, in accordance with law. My respectful submission here is that, my lord, kindly see page.
Then you have to file a CRLMP, non-action of the police. 482 doesn't lie.
No defect, my lord.
482 doesn't lie. You have to file a CRLMP, isn't it?
Inaction of the police.
Inaction of the police, my lord.
Then you have to file something else. The assignment is some.
But the police entertained the FIR but not implemented the proper section, my lord.
So those things you have to file another petition somewhere.
FIR was logged on 24/12.
You have first of all you have not implemented your husband. And your entire petition is regarding non-action of the police. So then you have to file another petition.
Lordship, police not taking action in accordance with law, my lord, in spite of the section is present, not implemented by the
How
police.
do you know?
Police-
Now you have filed the FIR when? You file, where is the FIR?
38. 24 December 20.
December 2024. Investigation is going on.
Yes.
You tell all these things to police and police will take care. I'll just pass that order. Okay.
Yes, ma'am.
Right. Petitioner is the informant in the FIR number shown. The grievance against grievance of the petitioner is despite a detailed FIR complaint given by her. The police is not police has not registered the FIR in the appropriate section, and the police is not also proceeding with the matter in accordance with the law. He has relied upon a series of documents in this petition to urge the aforementioned point. The FIR was registered on 24/12/2024. Investigation is still going on. At this stage, and I'm not inclined to entertain this petition. Our liberty is granted to the petitioner to place before the investigating officer all the documents which has been placed in this petition. If such documents are placed and the facts are apprised to the investigating officer, it is expected that the investigating officer shall deal with the same in accordance with the law while filing final report. From the court from 170. Yeah.
Especially, my lord, Muslim Women Protection of Rights of Marriage Act.
Yes, I have directed. Yes, next.
Yes, sir.
But the petitioner has filed this application challenging the proceeding, Lord, which is initiated against him. In this case, Lord, 7 witnesses have already been examined. None of the witnesses have accused the petitioner of the
What are you
involved
seeking?
petition in this.
What are you seeking?
But I am seeking the stay of further proceeding or quashing of the proceeding, Lord, enter proceeding.
The trial is at the fake and vice versa.
But trial, the informant and his family members, those are eyewitnesses, they have examined, they have said that nothing is.
So therefore, the more of a reason that I.
And the other witnesses there, that is their independent, they are not seen that. Those who have alleged against the.
I understand what you are saying.
Right.
You are saying the witnesses have not supported the prosecution.
Yeah, right.
Then what is the course? 482.
That's my lordship of the unnecessary.
Witnesses have not supported your case, then you will be acquitted.
That's true, that's true.
Here, the trial.
But is some cases, let quash this
No.
proceeding.
You show me
Some
one
cases.
case. Show me one. Trial is going on.
But
Because
when
the
there
witnesses
is
have
a-
not supported prosecution case, I can just take
But even-
file
But when,
and decide the case.
so when the break of the Cognisance is there,
I will target the trial. I'll
But-
just record that and target the trial. Don't
But-
confuse the process.
but lordship on the culprit records.
No, why should I do?
But see that.
You want to convert me to the trial court?
No, but this man.
Thank you that you have not asked me to record evidence about
No,
that.
that's true. But this man.
That's what
He's a
exactly you are
retired,
saying.
he's a retired lecturer.
Maybe whatever.
But the allegation not there.
482, when 482 can be invoked?
That's but he will call
You know
there.
that. See, the best relief which what you can get here is I can very well ask the trial court to expedite in view of the evidences which has come against you.
There's nothing.
I'll say that. I'll say that.
That's-
How many witnesses total?
All right,
targeted?
seven out of
Out of
17.
how many witnesses?
Just take that.
I think 16 witnesses.
16 witnesses, seven witnesses already there. They are all informants. There
Some of
are
them have not supported your.
nothing. Nobody.
So I'll ask the trial court to expeditiously dispose of that. Petitioner is seeking quashing of the criminal prosecution arising out of FIR number so on so. The sole ground on the basis of which the present petition is filed is that out of 16 witnesses cited by the prosecution in the charge sheet, 7 witnesses have been examined. All the 7 witnesses are vital witnesses to the prosecution. None of them have supported the case of the prosecution. Therefore, the petitioner through the learned counsel and counsel urges that continuation of the criminal prosecution on the face of the evidence which has borne on record as of today is it must be the futile exercise. Hence, he seeks indulgence of this court. Next one. Out of 16 witnesses, 7 witnesses have already been examined. Merely those witnesses have not supported the case of the prosecution. Is not the real cause to maintain the petition under Section 482 CRPC. Needless to say that when the trial is proceeding at an expected pace, the court, while exercising the plenary power under 482 CRPC, shall not scuttle the trial in between. Hence, this court is not inclined to entertain this petition. However, regarding head to the nature of the evidence which has come out of court and the trial has when the trial has started.
It is started.
And trial of the present case is pending since 2013.
Yes, 2013.
Since 2013, I'm inclined to directly code below to expedite the same. Yes. With these observations, petition. Next.
Within.
I have given. I'll just see how many witnesses are there.
Yes.
Here, next.
May I please before the last?
Yes.
My lord, here in this case, in typography, error will not 360 Act has been taken cognizance. My lord, your lordship has a glance in the page 18, my lord.
while the final report has submitted by the police after 2 years of the occurrence, one letter has been issued to the by the complainant. That has been final report in 341, 294, 323, 354B and 506. Thereafter, the complaint petition annexed to 2 Miller, page 19. There is also no 3 SCST Act, 341, 294, 323, 354, 506.
Yes.
My lord, cognizance has been taken, my lord, inadvertently 3 SCST Act, the informant is a Doitari Ponda, belongs to Brahmin Baita. Your lordship has a
Where is the, this is arising out a complaint, a final form, complaint?
final form is at, my lord, page 18.
Yes, show me the complaint, protest petition.
Complaint at page 19.
Protest petition if.
Yes,
the-
page 19 annexed to 2 Miller. Complainant, my lord, Doitari Ponda is a about DTS, son of late Dharmai Ponda, such and such. And there is no, there is also in paragraph 4 in nature of offense is also in the statute, there is not mentioned anything. At 341, 294, 323, 354 and 506. Inadvertently typographical error, it has been, I think it has been, there is no material resolve.
Where is SCST?
Yes, that is.
Huh? He is a Brahmin?
Yes, Sanapati and Ponda.
Ponda?
Liberty.
I'm searching.
For that is similar learning.
Where is the cognizance out of
My page 34, at page 34, my lord.
34.
Order dated 21/6/2018.
18.
Someone issued, my lord, that is cognizance taken in 3 SC stat, along with that.
Petitioner is agreed by the order dated 21/6/2018, whereby the SDJM Jagat Singhpur has taken cognizance of offences punishable under section 341, 294, 323, 354, 506 IPC, besides the besides offence under section 3 of SC. Counsel for the petitioner submits that insofar as the offence under section 3 of SCST POA Act is concerned, there is not a iota of allegation made by the complainant, in the either in the protest petition or in the inquiry under section 202 CRPC. I have perused the entire record placed before me. The present matter, initially the FIR was registered on registered 19/3/2015 by the opposite party, by the opposite party number 2 against the petitioner. After investigation, the police filed its report under section 173 CRPC dated 30/11/16, filed a closure report. Inter alia stating that no case is made out against the petitioner. The opposite party, feeling aggrieved by the same, filed a protest petition before the court below. Neither in the protest petition nor in the FIR any allegation of any allegations remotely related to the offence under section 3 of the ACXT Act was made by the opposite party. Moreover, the opposite party is a opposite party. Opposite party belongs to Brahmin caste, whereas petitioner is
Petitioner
petitioner belongs to a general caste. So therefore, there is no question of invoking the offence under section 3 of POA Act. Mr. Roll to appeal for the state and submits that in fact the cognizance of offense under section 3 of CST is erroneously has been taken by the trial court. Therefore, that part of the cognizance order may be set aside, insofar as the cognizance of other offenses, other penal offenses are concerned. I am not inclined to entertain this petition. However, insofar as the cognizance of offense under section 3 of SGST, the act is concerned, the same is set aside. Same is set aside.
On appearance, he may file a petition under
Do
section.
whatever. Next, yes. Yes.
Petitioner preferred with shareholders challenging the initiation of the FR as well as the consequential proceeding. Well, basing upon the co-accused statement, the petitioner has been added and accused in an offense under section 20B2C. I pray one thing.
All these things are co-accused only.
May I pray one thing? I am ready to surrender before the court below. While my bail application was considered, the judgment rendered by the honorable architect that should be taken into consideration.
If you cite, it will be taken into consideration. Cite it.
Your lordship may kindly observe.
Petitioner is seeking quashing up for the entire criminal prosecution initiated against him. In FIR number Dasapullah PS case number 152 of 2022. You are absconding, huh? After investigation, charge sheet has been filed in the present case on 31/12/2022, showing the present petitioner is an abscond. Then counsel for the petitioner submits that except the confessional statement of the co-accused, on the basis of which the petitioner has been implicated in the present case, no other evidence is emanating on record against the petitioner. Therefore, he seeks indulgence of this court. I am not inclined to entertain this petition at this stage on the sole ground that the petitioner is implicated on the basis of the co-accused statement. At this stage, the counsel for the petitioner submits the instruction that his client would appear before the court on or before 5th of March and resort to the remedy available to him under law. If he further submits that his case is directly covered by the judgment of Tufan Singh versus so and so. It is open. It is and Tufan Singh also. Apart from that, he submits that the co-accused persons have already been enlarged on bail. It is open for the petitioner to urge all the grounds before the trial court at the stage of deciding the application for bail, including the ground of parity. With this observation, the petition. Yes, next.
May I please, Lords? The impugned order is Annex 5. That is page 42 to 46. Lords. Before that, going to the impugned order, I have to submit the factual matrix of the case like this. Lords. This petition is the accused facing trial for the offence section 307 of Indian Penal Code. Lords. During course of trial, Lordship, one PW6, namely Rajesh Kumar Vera, has been examined and cross-examined. In the later stage, petition filed an application on 311 CRPC to recall the such PW6 because he is a material witness. Is required to be further question regarding certain confrontation parties concerned, providing the questionnaire fact etc.
Yes.
That has been allowed by the trial court. Thereafter, Lordship, summons has been issued again and again to the such PW6, but he did not turn to the court for further questions. And the process server both here, one the processor through court also and the police,
Yes.
both are submitted report that no such person is available in the address given here, Lordship. Although the address which he has been shown while depositing before the court below,
Yes.
that was in that address, Lordship, no summons has been issued.
I think I have heard this matter.
Yes, my lord. He also heard that matter regarding also recall parties concerned. Now here the case, your lordship, since the recall party's concern is not there, court said, your lordship, that person is not available in the locality. It cannot be possible to recall the same, your lordship. But here the petition is there, your lordship. When the summons has been returned, that no such person is available or not such person is hiding there in the.
Where is that order? I have
That
commented.
is also a glance, annex 5, page 42, your lord.
42?
Your lordship.
Yes,
Relevant page 43, your lordship.
yes.
Accused are present, file is very big, your lordship. Accused are present and file has.
Hey, what are you asking now?
My prayer is there before the Lord and court below that a prosecution introduced PW6 is not a genuine person. And if he is a genuine person, someone has issued to them, then the police cannot be said to fight some.
So then what? Then what?
I pray for a inquiry regarding that person is genuine person, not your lordship. If your lordship is not a genuine person, definitely lordship, the evidence will be expunged, your lordship. Or is a consequence upon to face the
You
prosecutor.
move such application, it was turned down earlier. That time you came to this.
No, that is not.
Where is my order? You show me.
That is in withdrawal.
Where is my order?
That is in withdrawal, lordship.
Ah.
That is withdrawn on the ground. So far the application 311 was filed, that is a recall so far PW6, lordship.
Yes, show me my order. I remember this. Show my order.
That order is not with me.
You get that order.
Now,
You
that
get
is
that
also
order, because I have commented about PW6.
That is.
I have allowed the application for the other witnesses and I have commented something about this.
Yes, sir. No. So far, lordship, a glance that a withdraw party criminal rate 264 of 2025, lordship. There, lordship, while withdrawing, given liberty to file an appropriate application before the court will.
Yeah, I will just dispose it up saying that at the final stage, the trial court will deal with this.
No, lordship. Now, lordship, my proposition is, lordship. He sort of lordship court, law and court said that lordship, at this stage, it cannot be said to be that person examined, which is a genuine person, not to genuine person. It cannot be said because we are failed to produce an evidence to that effect. My respectful submission, the evidence is very much clear that since the process server and the police said that that person is not able, the process.
Not available doesn't mean that he is not a genuine person. Suppose a labor, he came and deposed, went somewhere else. He's not available today.
That can be said, lordship, but they are not saying so. They are saying he's.
You are unnecessarily stretching it too far.
No, lordship, I am not pressing your lordship any stay, your lordship.
Show me my order because I categorically remember I dealt with this.
Keep it to next week.
Show me that order. I have said about this.
Keep it to.
I knew while passing that order, I knew that you would be approaching this court.
Correct, your lordship.
Therefore, I have one paragraph I have written it.
Yes, correct, your lordship. I'll place your lordship that order.
That's perhaps the reason you have not filed it.
No, your lordship, that is that.
I remember because I asked them the very specific question. If you have an examine a witness and the recall application was allowed and that witness is not available, you say that he's not available, he's not there at all. I know that you move an application for recall of the witnesses, including this witness. Show me, okay. Show me that order. List it next week. Yes.
Okay.
Yes.
30.
Yes.
Page on my left.
Page on.
NPW was issued on my left. Page my left 9, 16/12/2024. Bail my left. There is two-phase bail. First on 25/8/2021, petition number 1, and then 22/9/2022, petition number 2 and 3.
Okay. 2 and 3.
Yes, sir.
Okay. 500 each. High Court work. Next.
14.
Yes, sir.
Like this, petition challenging the order dated 27/12/2024, where the petition filed by the petition with regard to the release of the bank accounts and some documents which have been seized. Now they have filed the objection before the trial court, my lord. They have stated that they have not seized anything, despite the fact the court has so much to pass the order that the petition is rejected. Your lordship, kindly turn to.
Where is the seizure list?
Seizure list I have annexed, my lord.
Where is that?
Page 19, your lordship.
19?
19.
Okay.
Despite that, they have filed the objection, your lordship, page annexure 2, page 32, my lord.
19, huh? 1 minute, 19.
They have given the list, seizure list.
Yeah, this is seizure list.
Nice.
So which are the articles? You're talking about documents.
Documents, my lord.
Same document you are
The
asking.
petition is the wife of the accused.
No, same document you are asking.
Yes, ma'am.
Yes.
Your lordship, turn to their objection page 30.
32. Okay.
3-2, ma'am. Annexure 2.
Yes. Yes, which part?
Para 2 minor, Roman 1, that in connection with the report CLLMC and subjects cited above, it is to intimate no bank account was seized and documents seized by Srimati Vidyasri of Srimati Vidyasri.
Yes, sir.
And now the order has been passed.
Yes, sir. Because seizure list you have seized, and in the objection you say that I have not seized. The seizure list there, these documents are there.
I've gone through it. Let it come.
Okay, I'll just issue notice.
The first time is coming. Let
Yes, issue
notice go, my lords.
Issue notice. Draft accept notice. ठीक है? Please the matter. Yes.
But I'm afraid he has filed another one.
Earlier filed at the intervention of this honorable court of the you have
The reference then anyway. We'll
That is bail matter, maybe.
No,
Huh?
this another
another account.
the young
This is not.
no, same petition. I know that the lady, the small.
Then why are you coming installmentally for every document one application?
Anyway, I'll look.
You have to file one consolidated application, not that suppose 5 documents are seized for every document one application.
That is disclosed. That is not.
You have to disclose that.
Thereafter, we have filed the petition for release, and since they have rejected.
Right away. Mr. Das at the outset submits that the same petitioner had already approached this court for the same cause, which has already been
not same documents.
Whatever his objection, which has already been disposed of. This aspect of the matter is not coming forth from the petition filed by the petitioner. Mr. Kuntia seeks to place on record the order by which his earlier petition was disposed of. Yes,
In fact, page 38 will also to page.
You
filed it.
Yes.
Yes. Next.
Page 38 also indicates that earlier the petitioner opposed this.
Let him place on record. Yes. Next. Yes.
May I please, Lord?
Yes.
Bail granted on 2/11/22, my lord, and the NBW issued on 31/24.
20?
24.
24. 500. Yes.
So obliged.
Yes.
My lord. Bail 11/1/2011, my lord. Page 6. Belgium, my lord, 7/12/2024.
Okay. 500. Yes.
Belgium matter ordered 29th April 24.
Yes, bail. When you got bail. Do you have idea when you got the bail? No.
Yes. This is the stage of accused statement. In the year 2015, bail impala.
2020 bail is about 500. Yes. Yes.
पंदर 4/24 लॉर्डशिप रिलीज 4/1/2024 को रिलीज लॉर्डशिप जेतु पर्सनल आज ऑर्डर हेतला
Okay. 500. Yes.
Pass over.
What password? Tell me. Huh?
24/8/2022
Yes.
18 their separate date of release and bail.
18?
March 2017 is the date of release and bail.
Okay. 500.
Implemented 24/8.
Yes, 500. Next.
20 list lordship on bail 17/10/2015 NBW 3/4/2018
3/4/2018.
18
1000. Yes.
21 lordship earlier on bail NBW issued on 2/1/2019
21.
19
Again, same 1000.
Belgium matter, my lord, NBW was issued on 21/4/2022. Bail was on 30/6/2014.
22, na? 500 each. Yes.
23.
Raigada.
Belgium matter, my lords.
Raigada.
Belgium matter, my lord. Earlier petitioner was on bail, my lords. NBW was issued, my lord, 27/6/2011, my lords.
NBW 11.
My lords.
Oh, good. 2000. Puri.
My lords.
Puri 2000. Puri.
2000. 1000.
Check. 2011 you come. 1,000.
ସେ ଓକିଲଟା ଯେ କଣ୍ଟାକ୍ଟ କରିଥିଲା ସେ ଆଜ୍ଞା ଏକ୍ସପାର୍ଟ କରିଗଲା ତେଣୁ ଇଣ୍ଟିମେଟ୍ ଆଉ କରିପାରିଲା ଲାଷ୍ଟକୁ
You are giving to the bar after all. What is this?
1,000.
No, he paid 2,000. Okay, 1,500 you paid.
NPW
Bar, you are paying you to your bar. What is?
Lordship, NPW issued against 9/8/2024 and release on bail 8/7/2020.
20.
Release on bail. NPW is 9/8/2024.
Okay, 500. Yes.
Okay.
500. 25. Yes, 25 bail. Bail.
In the case, the
Case there is there.
preliminary charge sheet has been filed.
Uh-huh.
For supplemental charge sheet, some time has been paid by the concerned.
What are the offenses?
Offense 302 and 201.
What is there?
Beyond circumstantial evidence.
Urgent. Nobody is there.
26. My lord, I'm praying for Passover.
26?
Yes, my lord.
Okay, Passover.
27. May I please Lordship, the petitioner custody since 27/4/23
1 minute.
and charge sheet filed on
27? 27?
27/4/2023.
Yes.
Charge sheet filed on
2024.
2023. Charge sheet filed on 23/10/23.
23, okay.
Alleged offense 20B2C. The quantity is the
1,091
kg.
Only.
Near about 2 years. 45 charge sheet witness, no witness still at exam.
But see the quantity. Ravi Prakash will not also help you.
CD
1,000.
ଗୋଟେ ବି ସାକ୍ଷୀ ହେଇନି
That's right, but what to do?
CD ଟା ନହେଲେ ଆସୁ।
Bail was rejected on 18/11/2024.
Oh, wait, why are you coming so frequently?
ଆସୁ ନହେଲେ
For the March for a day. 1 month. After 1 month. You should wait immediately. Today rejected, tomorrow you come and get an adverse order. What is the use? Wait till the yes. 1,000 kilo recovery. Yes.
28. 28 is the case of the 376.
Yes.
And
Madam is there. Yes, madam.
May I please, Your Lordship?
Yes,
Your
madam.
Lordship, charged under section 342, 294, 323, 354, 376, 506.
Custody. You tell me custody.
Custody since 4/2/24, but he has been released on interim by Your Lordship.
he was there. He thereafter we violated.
Oh, you got interim bail. You have never surrendered.
No, surrendered. He surrendered on 18/12/24, Your Lordship.
18/4.
18/12/2024, Your Lordship. He surrendered.
Interim bail granted by this court.
This court, Your Lordship.
Where is that?
That Your Lordship and
Yes.
come to page 28.
Yes.
At least you have previously released the interim bail by the order of the BLPL number 1695/2024. Failed to surrender after last time interim bail. Honorable Court has been pleased to dismiss the bail application 1695/2024 filed by the acting by the office dated 7/8/2020.
Yes, madam.
Your
Why
Lordship.
should you get the bail? You don't respect the order of the court.
Your Lordship, trial is being commenced in the court below, Your Lordship. And
Trial completed.
no, Your Lordship, I think out of 15 charge sheeted witnesses, 12 have been examined till now. The victim and victim's mother, the informant and IO is yet to be examined, Your Lordship.
Then you approach the court. I am disputing that. You approach the trial court. And counsel for the petitioner seeks to withdraw the bail application to renew his bail before the trial court in view of the subsequent developments which take place, namely in view of the fact that vital witnesses have already been examined in the meantime. The bail application is dismissed as withdrawn with liberty as granted. Yes, next.
29.
Man, please, Lordship, alleged offender wants to 420, Lordship. Petitioner is
Sorry,
for
sorry,
420, Lordship.
420, okay. Custody,
Custody, 5/4/2024, Lordship.
5/4/24, okay. Yes. Custody 5/4/24, yes. What are the allegations?
Cyber crime.
Cyber crime, Lordship.
Cheated 85,99,000.
Yes. Are you preparing the case right now or you have already prepared? Are you preparing the case right now? Or you have ready?
No, sir.
Are you then?
That's it. I have let it come other day, Lordship.
I see. I know. After 1 month. After 1 month. So,
Escaping. There are
April.
digital transactions.
Yes. Yes. 30
Your Lordship, adjourn it, my lord.
April.
My lord.
Yes.
My Lordship, my lord, this is second round application.
Yeah.
And the offence is 302.
Hmm.
Custody about 1 year, my lord. 3rd February 2024, my lord.
2024.
3rd February 2024, lord.
3rd February.
Yes.
Yes.
And allegation is, Lordship, that petitioner committed murder to his second wife of my lord.
Second wife.
Yes.
Okay.
Here, my lord. There is no eyewitness basic of the circumstantial evidence he is convicted. Custody, Lordships.
Yes.
Here, initially, my lord, the education was registered. Subsequently, after on to the record that was turned to the FIR, my lord. And 14 days after, FIR was lodged, Lordships. And the Lordship kindly see. And that so far as the postmortem report is concerned, cause of death is due to asphyxia due to constriction of neck by legislative material, Lordships.
Where are you reading?
My lord.
Where are you reading?
Yes, the postmortem report, Lordship.
You have not filed except FIR, nothing is filed.
Yes, I have filed FIR, my lord.
Where is it? FIR you have filed? What else? And counsel for the petitioner seeks
Right,
an adjournment to place on record the additional document to substantiate his case. Let him be to file all the documents. This is the matter. And call for the CD.
The 9-year boy is the witness, my lord. His song.
Yes.
I know I've seen it, so therefore I'm just adjourning it. To file it. Yes. Yes. 31. What is the stage now? In this case?
My lord, trial is not started, Lordships.
Trial not yet been begun. Charge has framed.
Charge has been framed.
My lord.
Yes. 31. 31. Next. Number one read the.
31, my lord.
Yes.
All three, in the meantime, 3 prosecution witnesses have already been examined. 2 witnesses have already supported the prosecution case. It is a PR case. Probably trial has been over.
Over.
Probably, my lord. Your lordship. Because there are 3 witnesses, my lord. All 3 are examined.
No, when the last witness was examined, can you tell me?
It is in the rejection order, page 11, your lordship.
Okay. I'll just
3 prosecution witnesses have already examined.
I'll just ask for the report.
My lord.
Ask for the report. Call for a report from the trial court. Yes, next. 32. Adjourn. 32 adjourn. We call for the report again to April 33.
Item 33, my lord.
Yeah.
Have a glance to page 17.
17?
17.
Yes, sir.
This I have approached earlier referred this on court, my lord. And this court directed to examine the eyewitness, the wife of the deceased, to examine him within 3 months of time. The order has been passed on 1/8/2024. Till that she has not been examined.
So then wait. Yes. Wait till she is examined.
But the fact is that the husband and wife sleeping near the veranda of PMG Square. One person came and there was a tussle between both, and he called Gedu.
But see, para 5 of my earlier order, just see. I have said that in view of the same, so far as the petition number 2 is concerned, he can revive his bail application after the examination of the wife of the deceased in this case.
My lord.
Let the wife be examined.
My lord, para 7, my lord. Para 7. The wife of the deceased who is eyewitness and independent witness shall examine within 3 months from the date of receipt.
I don't know for what reason. You might have taken time. Who knows?
Yes. But let the report.
No. The earlier bail plea of the petitioner was rejected by the order dated 1/8/2024. However, liberty is granted to the petitioner to renew the bail plea after the examination of the wife of the deceased. It is also observed by the said order that the trial court shall do well to see that the said witness is examined within 3 months. 3 months. Let counsel for the petitioner submits that even after the expiry of 3 months, the witnesses, the wife of the deceased has not been examined, hence he repeated the bail plea. However, nothing is emanating from the record as to why the said witness have not been examined. Be that as it may, I am not inclined to enlarge the petition on bail at this stage before the examination of the wife of the deceased, and it is accordingly directed that the trial court shall do well to see that the said witness is examined preferentially over all other witnesses. Thereafter, the petition may renew the bail plea. With this observation, the petition will dispose of. Next.
My lord, after examination of the my lord,
I've given it. Don't worry. I'll protect your rights. Okay. Yes. Yes. 34.
My lord, after getting the order, they have issued the notice several times to the witness, my lord.
That is why I said that preferentially, if it doesn't happen, then you can renew the bail. That's what I said. You can renew the bail.
My lord, time not the
Therefore, in the petition, while drafting the petition, you should have said all these things. When the notice was issued, why he has not come, nothing is coming out in the record. One page petition, file it. What can I do? Tell me. Your petitions are being drafted in this fashion.
Sorry,
what can I do? So therefore, next time when you draft the petition, you should be careful. Next. 34. Yes, 34. What do you want, sir?
My lord, 302. Here, my lord, 8 witnesses has been examined and they have annexed also. PW6 has corroborated the prosecution case, 6 and 7. Apart from that, there is not
April.
35.
Second round bail application, my lord.
Yes.
The petitioners alleged to have committed offense under 302 and 201, my lord. The fact of the case is like this, my lord. While the petitioner, along with her mother-in-law, slept on the house, the petitioner has alleged that the informant alleged that petitioner has murdered the mother-in-law. Now the petitioner is in jail custody along with her newly born baby, my lord, and she is languishing in jail custody from the date of arrest, that is from 6/12.
What is the custody since? Custody since?
Custody since my lord, 8/12/2023.
8/12/23.
Yes.
Yes. What do you say?
Yes, diary is
a lady.
Baby. Charge yet to be framed, my lord.
I have quoted.
Charge has not been framed yet.
When
charge sheet has been framed.
Charge frame charge. Charge frame.
Charge has not been framed. FIR was registered in.
And my lord,
on 8/12/2023.
Weapon of offense has been seized. Weapon of offense, iron rod has been seized. The present petitioner killed her mother-in-law.
Alleged to have killed.
No. What are the evidence?
Evidence, my lord, case diary is not with me. Right.
Call for case diary. Yeah? Call for case diary. I think she is a lady, 22-year-old girl, and
while she is in custody, he has gave birth to
infant girl, boy is there.
Yes.
We call for case diary after 2 weeks. Yes.
36.
Yes. Yes, sir. Yes, sir.
Your petitioner lordship is the husband.
Husband.
Yes, he is in custody since 21/1/2024.
21,
1, 2024.
24, okay.
Their offenses are there 294, 304B, 306, 323, 34, 419, 4 DP Act.
Yes.
And marriage in question was taken place in 2018. This is along with the petitioner.
Allegation, you tell me.
And that on account of demand of dowry, she consumed poison.
Poison, yes, madam.
And the
Consume poison, Jesse, medical evidence you have?
no, my lord. Page 10,
10.
FRA, that is.
Medical evidence is there.
No, medical, I don't have.
Nothing is there. Call for case. Call for
And
case.
case has been committed, trial is yet to commence.
2 weeks, yes, 2 weeks.
Let's keep it or else.
2 weeks.
37.
If you have the charge sheet with you, why don't you file all these things? Why are you depending the prosecution? You need bail.
Let's keep it next week in the meantime.
Meanwhile, you file it.
Yes, sir.
You only FIR, you file nothing else.
Yes.
And now you depend upon the prosecution.
Yes.
Prosecution will come.
Yes, that is there.
You are in custody.
Yes,
You
yes.
are in the
Yes,
custody.
yes, sir. Yes, that is.
What is this
should have
practice?
been-
I don't
yes, yes,
understand.
sir. I should have been filed.
You file anything, then say that call for the case diary. Why don't you? Everything is
yes,
there with
yes.
you. Why
I
don't you
do,
file?
I do admit, my lord.
And you are doing disservice to the.
Yes, yes, sir. Yes, yes.
Right.
No, that is.
And the charge sheet is given to you. You file the entire charge sheet.
Yes, yes.
Only for that charge sheet, 2
Yes.
days or 3
Yes.
days.
But keep it next week in the meantime.
2 weeks. I don't know whether you can file or
A
not.
week after. I have today itself.
2 weeks per.
10 days per asu. In the meantime, I'll file.
You file entire document. That's
Yes,
a better
yes,
idea.
yes, yes.
Yeah, 30.
37.
Make a mention.
Yes, sir.
25 is a 25. Item 25. I was in.
What is it? 25 adjourned. Pass over, huh? Pass over. Okay. Pass over. Okay. Next.
37.
My lordship, it is a 302, my lordship, and it is a FIR and counter FIR. That is between no civil, there is a civil dispute. For that, my lordship, two brothers fight with each other and they assaulted, and one brother was dead.
One brother killed the other.
Yes. And the other, my lordship, there is a postmortem report and also the injury report.
Okay. Since nobody is there, adjourned.
My lord, item number 38, I'm saying.
All these matters where the bail is not to be granted, all these are bails are held here. Very difficult to find out grounds to give bail. Yes. Yes, madam.
Item number 38, I'm saying for pass over.
Pass over. Okay. Yes.
39.
May it please, your lordship. Item number 39, my lord. In
Yes.
item number 39, 3 matters are there, your lordship.
Last
single-
opinion, your lordship has directed me to check the judgment that they have given. And as for the judgment, my lordship, it was covered. But one thing in my lordship, in the judgment, it said that in the order, it said that they have no criminal antecedent. As my friend said that last occasion, they have one criminal antecedent.
No criminal antecedent, my lord. Not single criminal antecedent, not the similar offense, not other offenses.
Okay.
But the
One
quantity
minute. 1 minute.
is a commercial quantity, and as per the order of the Honorable Supreme Court, my lordship, it is covered.
Ravi Prakash.
Yes.
What is the recovery here?
154 kilogram, 400 gram of ganja, your lordship. From 4 person. If we will segregate, my lord, it is 38 gram something. 38 kg.
And here is
But the segregate principle, where from you got?
My lord, if 4 person transporting 154.400 gram ganja, then they will be distributing, your lordship.
What do you say? 1.5 years.
yes, ma'am.
Already undergone. 150 kg. In the Ravi Prakash, 247 kg.
And
For
3
3
years.
years.
And custody there in that case?
3 years.
3 years.
3 years.
No.
We have no criminal antecedent except this case, your lordship. For that reason, we already filed the affidavit, my lord.
Grant.
Yes.
Yeah. Madam. Out of and in all the cases, no criminal antecedent.
No criminal antecedent. Your lordship.
And the problem is, few of you are from outside.
Two person are from Maharashtra, your lordship. They are ready to cooperate with the trial, your lordship. They will not leave the jurisdiction of Orissa also.
That may be.
That's the problem. Once
Yes,
you
ma'am.
grant the bail, then it
Yes,
gets
my
stuck.
lordship.
My lord, they will not leave the jurisdiction of Orissa.
Okay,
That condition, your lordship.
who all are the outsiders? Abhijit Vaidya.
Abhijit Vaidya and Swapnil Sande.
You,
The two person are from Maharashtra.
have you filed the affidavit?
Yes, your
stating-
lordship. Yes, your lordship.
Where are you going to stay?
My lord, my original address in the affidavit is mentioned, your lordship.
Now you have to give the your local police station number and superintendent police number and all. Otherwise, it's very difficult. We have a very bad experience of granting bail outside.
At the time of release, my lord, I will submit all the details before the learned court below.
You filed the affidavit here.
My lord, we already filed the affidavit showing my residence.
That's right. You file an affidavit disclosing the police station where under which jurisdiction you are going to stay, and the phone number of that police station and all, and the court will verify thereafter only.
Yes. My lord, if verification is required.
1 week I am giving next week.
The learned court below can verify everything, your lordship. At the time of grant of bail, the learned court, if your lordship.
So that will take more time. If I give, then months together you will stay. Better you give affidavit. I'll release you on bail, and the trial court meantime verify. That's a better next week. Before insofar as which item Abhijit Vaidya and
Swapnil Sande. So for the middle item is concerned, my lord, he is from local. He is from within the state of Odisha.
Haricharan Golaria is local.
Yes, my lord. 1851.
Local. Okay, you file this affidavit next week. Next week. Affidavit. Counsel for the petitioner submits that the petitioners outside of the time submits that the petitioner belongs to Maharashtra, and they would be filing an affidavit disclosing that the local address, police station, the phone number of the phone number of the police station, and the phone number of the police station. Release the matter after 1 week. Yes.
Sub-item, my lord, that is local person, my lord. Sub-item.
I'll have to, because I can't distinguish local and accused is accused. I have to grant bail means everybody.
Yes.
Merely because they're outside, I can't deny them. No, we have to ensure that their presence is to be.
Yes. Grateful, man.
May I please? An application for modification of order dated 15/3/24, my lord.
Yes.
My lord, modification of order dated 15/3/24, my lord. In this case, my lord, your lordship directed the petitioner to be released on bail.
Last occasion, my lord, I seek time for taking instruction. Early instruction I have because out of outsider. So any stringent condition because
petitioner is
what happening in all cases, those are outsiders. Once they are getting bail, they are going away. Then either they are cooperating.
What modification?
My lord, para condition number 3, para 6, my lord. Your lordship directed the petitioner to be released on bail. Also directed to appear before the IO Narcotic Control Bureau, Bhubaneswar, once in every month, and also appear before the learned trial court. Petitioner, as per your lordship's direction, petitioner is appearing before the learned court below and also before the IO. My lord, in this case, my lord, charge sheet has already been submitted. Police paper has been already supplied. My lord, so far as the appearance before the IO Narcotic Bureau may kindly be waived out, my lord. Petitioner belongs to Nadia, my lord. West Bengal, my lord. Charge sheet submitted, my lord. Police paper has already been received.
But my lord, this department regards that because whenever that is fixing the court below, that day will appear. We are not given specific date to come to one date to us and another court.
No. What he says, after the charge sheet is filed, why should he go and appear before NGB? And appearing before court.
My lord, last 2 days he is not coming to the court, not to the NCB officials also. Last 2 days. He is not established a bona fideness. Because the outsider we have some restriction.
Then you respond it. Response. Okay. Just simply issue notice. Yes, next.
My lord,
I just issuing notice, let him respond. Yes.
my issue notice, my lord.
41. Please, Your Lordship,
You
item
will
number
file
41.
response. Yes. Yes.
This is an earlier disposal case. Kindly have a glance to flag T of Your Lordship's file. It's a tied up matter in bail number 3128 along with bail number 50.
Flag D for Delhi.
Flag T. Flag T. Earlier disposal case of Your Lordship.
Okay.
Saroj Kanda.
Flag P.
T.
T for
T for
Tamil Nadu.
train. T for train.
Train. Where there is no flag.
Flag T of Your Lordship 5907. Item number 41. This is an tag up file. I'm appearing on behalf of the second co-accused.
I am appearing for the first co-accused. Thereafter, you will admit.
Surely. Yes.
Yes. What do you want?
Yes, sir. So far, the 3128 is concerned, my lord. Present petitioner is behind bar, my lord, since 10/3/2024, my lord, being charged sheeted under section 419, 420, 467, 468 of Indian Penal Code, my lords. And you also would find from the narration of allegations, and there is extremely slow progress of trial, my lord. You also would find from the charge sheet, my lord, charge sheet has been filed since and charge has been framed and first day of taking evidence was fixed on 28/8/2024.
You are arguing the second matter.
First main, my lord.
Okay.
Charge sheet has been filed 27/2/2024, my lord.
27?
2/7/2024, my lord.
Yes.
Against the 3 persons, my lord. And thereafter, charge has been framed, subject to verification by the Law and State Council, my lord. First day of taking evidence was fixed on 28/8/2024.
Yes, madam. You have the papers with you.
My lordship, last occasion, your lordship was directed to see whether the petitioner Angel Mishra, they have filed an affidavit that she is not well in the jail custody.
No, we have not filed an affidavit.
Yes, I have.
No.
The first matter has to
No.
My lordship.
Last occasion, lordship directed the Law and State Council to produce the case diary, my lord.
Case diary is there, my lordship. But the bank is also.
I am for the bank.
Yes, my lordship.
You are in on interim bail.
No, of course, I was released on interim bail. I did not avail that interim bail in view of a pendency of other cases against me. On the same day when I furnished the bail bond and I was taken into custody in another case for which I failed to avail the benefit granted by this honorable court, my lord. So my contention before my lord is that all the alleged offences are tried by the learned magistrate, my lord. And
what about the other cases?
Other cases.
How many cases do you have?
Subject to verification, 3 cases, my lord. Subject to verification by the Law and State Council, I have been
3 cases total. Total, how many cases? You file a status report regarding the number of cases he has, both the matters. Mrs. Morana responsible for the state to file a status report regarding the number of cases pending against the petitioners, petition both the cases. At least after 2 weeks. File it.
Yes.
Let us see.
At
least you should know how many cases are there. I get grant bail in another case, you will be arrested. What is the
status report from the trial court be called for with regard to the status of the trial, my lord? Till today, my lord, not a single witness has been turned up, my lord.
Yes, your lord.
When was the FIR?
Charge sheet has been
charge sheet is February only.
2/7/2024, my lord.
That's right, February.
Charge has been framed, my lord.
Framed.
Charge has been
amount of the public money are involved.
The Law and State Council just to
1 minute.
Sir, just 1 minute, you will advance your argument.
Let us see how many cases are there against you. Thereafter, I'll call. I'll call.
Item 42 by same item
42 same. 42 भी same आ गई.
The presence of the bank may kindly noted.
All the presence.
Okay.
Item
And you prepare a chart and give. What are the allegations against all the this thing? What are the allegations and all? You give it so that it will be easier.
Yes, sir.
Then I can. Huh? 78. Parties are there. Parties have come out. Yes. Parties. Rana Pratap Singh.
Yes, ma'am. The husband.
Ramani Singh.
51 kg contraband seized from two number
Yellow.
of persons. Also.
Uh-huh.
51 number of contraband. 51 kg of contraband, my lord.
Lordship's last occasion directed the trial court to submit the report. A report issued from the session judge Ganjam. On Pachishek, these are
Flag C. Flag C. Learned State Council referring to Flag C.
She is a man of woman of Bihar.
See, that's the problem. One of the co-accused, Mukesh Kumar, was enlarged on interim bail. He absconded.
But my lord, see the
Your friend is absconded. Therefore, the trial got delayed. Now the trial is split up. And now you will go out. You will never come. This is the whole difficulty.
If I will enlarge on bail, I will obey all the terms and conditions.
He also said the same thing. You don't know. He has also said the same thing.
But my lord, I am ready to file the affidavit regarding the local police.
He also might have done the same thing. Now
I
we
am
are
a lady,
searching.
your lordship. I
And
am
the
a lady.
court is searching. And everybody is searching him. Who is Mukesh? Who is
Mukesh
Mukesh? Mukesh is
another co-accused.
Kumar Patna.
Patna.
But my lord, I am a lady, your lordship. I am languishing since 11th November 2023 in judicial custody.
11 November
2023, my lord.
23.
And the quantity is 51 kg.
Hey, that's right. You are entitled to bail, no doubt. But the
I am
problem-
not the owner of the vehicle. I am the
letter filed an affidavit. So which station, police station?
The same type of affidavit you file.
And also the local security which she wants to provide.
Yeah.
Next week, your lordship may kindly place this.
Petitioner is in custody since 11/11/2023. The 51 kg of contraband has been recovered. At the last date of hearing, a report was sought from the trial court. So the trial court, by this report dated 25 January 2025, has intimated this court that out of 4 PR witnesses, one witness, namely Biraja Bihari Naik, has been examined. The trial has the co-accused Mukesh Kumar was enlarged on interim bail. He did surrender back after the expiry of the bail period. Therefore, the trial for the said accused has been splitted up. And that's the reason the delay. That's the reason the trial for the present PC has become delayed. At this stage, land counsel for the Mr. Sahul and counsel for the petitioner submits that he would be filing an affidavit disclosing his local address and police station and the other particulars disclosing his independence as well. Yes, please see that for this means.
Grateful, your lordship.
44.
Yes. For your lordship's last occasion directed to obtain instruction matter. And in this case, instruction has not come.
Awaiting instruction pursuant to the order dated 31/1/2024. State council has after seeks an adjournment. Leave the matter. Yes, next.
45.
Item
45, let's say, next week, meantime I filed the copy of
Request
the
for the council for the petitioner. Please the matter on. Yes, sir.
46.
Last of the instruction of the final deposition.
Yes. Yes.
In the case, my lord, there are witnesses are there, my lord. And they have supported the prosecution case. 6 witnesses have been examined out of
13 already examined.
13 examined out of 18 men. And all have been, my lord, supported the prosecution.
Yes, sir.
13 the deposition dina 6 dijon, but
Here, that's 302. Mamu Honaja, Lordship, that is the Mam, one of them are the Mamu. Both are more than 70 years old.
Bhanja has a right to kill the mom.
Lordship,
That's the moral of the story.
That has happened here, Lordship. Only period of detention, Lordship, kindly consider that was that may
That's
be
right, but all the witnesses have supported the prosecution. What
that
to
is
do?
that is there, Lordship.
Then-
Lordship, that is there. Only Lordship period of detention may be considered.
Period of detention is something different.
target.
No. Buddha Logoda can jail the
After conviction, he has to be there in jail.
No, that's true, Lordship. But
It's pure short case of conviction.
maybe
All the witnesses and unison there.
Jode witness le so jaijibo.
No, that's true.
The only thing is he's 70-year-old. That's the
Lordship,
only thing.
only Lordship. That is the only consideration Lordship can be.
But if the witnesses, how will you have to say something?
If convicted, definitely will go to custody.
My lord,
That's
if
right.
18 out of 18, my lord, 13 as per my woman brothers.
Yes.
13 have been examined, my lord, only 3-4 witnesses. If your lordship will target the case within 3 months, that can be concluded, man.
No, the target is now bent because of the judgment.
Again. No,
While-
this is a peculiar because age, factor is age. Your lordship can consider that aspect.
Only age. Rohiland, there was some.
Consider करिए ସେଇଟା को target करते हैं.
No, target by Mukuni. Lordship kindly allow me for some period.
You move an interim bail.
Interim, I will move interim, my Lordship.
Let him move.
Lordship, let him next week, Lordship.
Yes. I'll put it next week. You move an interim bail application because his
Lordship.
age is like that.
Lordship.
I will allow you the interim prayer and you participate.
Lordship, I'll participate.
Participate.
Lordship,
Okay.
grateful.
Next week, huh?
Next week.
Tuesday, lagay. You move application.
Lordship,
On the health ground, you make some.
Lordship.
Yes.
47.
Item 17.
But in any case, it will be interim because you will be convicted. So it will be interim only. So better you move an interim only. Yes.
My lord, item 17. Party is unable to attend the court. I don't know.
Next week,
Next week.
bring them on online or something. Or if somebody can't come. 1 minute, somebody is not in a position to come, at least move an exemption application explaining why he is not coming. At least something has to be there on record. Okay. 7 accused persons are there, only 1 has come. How can it be caused like this? Yes, sir.
My pleasure, lordship.
Yes,
My
sir.
lord, in the last occasion, I have prayed for regular bail. This offence is, my lord, as per allegation, 20B2C 29 along with other allied offences. That is 341, 294, all are magistrate tribal offence. In the last occasion, my lord, my senior state counsel has got some instruction regarding showing of the judgment that despite of seizure list and recovery of possession. 29 ta applicable. Despite of presence of seizure list and recovery of possession, along with payment chart, how section 37 will be a bar to section 29 because 20B2C offense committee है because माल नहीं कि semane पड़ेले. So there is no recovery of possession from any of the accused persons. Neither they have divided in the allegation in the FIR that the mal was weighing of 2.5 quintals. Without weighment and without possession, how come they have got mal was contraband ganja was of 2.5 quintals? I fail to understand. So for that reason, my position was that though no offense has been committed of 20B2C, so replicably 29 cannot be attracted to that because it is also an independent offense. So it depends on the main offense. When offense has not been committed, how 29 will be there? And against that, State Council has produced that 37 will be a bar to 29. With that, my lord, kindly have a glance to page number 35 to 38 of my petition. 35 to 38.
Yes.
The prime accused person, Benia Mohan Biro, he has filed an CRLMC in which matter the Honorable Justice Aditya sir has given
Cognizance order.
My lord. In that, my lord, in the last paragraph 6, last line. The as such, the bar under section 37 of the NDPS Act would not be attracted to the facts of the present case. See, the prime fact, the prime accused, Jahara contraband ganja thila, he took and he fled away from the spot. With that, my lord, though it was admitted to be issued in that. Your lordship.
Your custody since?
Custody since, my lord, 9/8/2024. FIR date is 10/3/2023. After 1 year. After 1.5 years, my lord. There was a part of the charge sheet at 1/8/2023. Copy of that.
Yes.
The wedding party went to the my lord, house of this petition, that main accused, my lord. This main accused and this petitioner, along with 3 others. Total 5. They have collected the huge quantity of vodka and kept inside the room. Then police party has went to that room. They have seized that 250 kg of vodka. Then this petitioner, along with three, four persons, they have taken away the accused and also that contraband gunja, and fled away from this spot. Assaulted the police personals, and they are the malad, as per the charge sheet, malad, they are the habituated with the habit of selling the contraband.
How many cases are there against him?
No single antecedent, my lord. Absolutely no antecedent. That may be recorded, my lord. Case also, I have given the charge. And for that reason also, session judge rejected.
What is your name? Your name?
Kristoraj Biro.
Huh?
Kristoraj Biro.
Biro. Kristoraj Biro.
The private which is Benia Mohan Biro. And the other alert offences in which, my lord, 341, 294, 323, 354, 147, 148, 186, 332, 149, all are magistrate tribal offences. And the highest punishment is 350 or 5 years, my lord. And he is inside custody since 9/8/2024.
What happened to the Benia Mohan's case? He got the bail.
In that matter, he has applied. We have given the order and he is applied for bail. Till it's in consideration period, as because it is a CRLMC case.
No, you have shown me this order.
My lord, CRLMC. We have given the order to the lower court and they have filed it, my lord. It is on consideration. Kichi case record asila para, it will be hearing.
Okay. Let us see what happens there. Okay, you file an affidavit that you are antecedents and all.
No antecedents.
You file an affidavit. Then it comes for the petitioner to have to file an affidavit showing, giving details about the antecedent, if any. lease the matter out.
Well, one date maybe, it is very short.
But he is entitled to bail, Mr. Let him give affidavit. I'll say. Yes.
Well, date may be fixed.
And date.
Obliged, deeply obliged.
Because see, the CRLMC, there is a finding, the 37 doesn't attract, and they reach subsequently. Yes.
May I please, my lord? My lord, the petitioner is in custody since 16th September 2023, your lordship.
Yes.
On an earlier occasion, your lordship had suggested that after completion of 1 year, he should move for bail. 16 September 2023.
23, yes.
My lord, this is a case of seizure of 155 kg of contraband from a place where the petitioner doesn't stay, and that house belongs to 3 brothers. And the petitioner is actually a home guard who is staying in a different place, who is in R. Udayagiri. The seizure has been made from a house which is jointly owned by 3 brothers. Your lordship, he has already spent more than 1 year and 4 months, your lordship. No conscious possession, not even exclusive.
Yes.
My lord, he is a home guard man. He has to assist the police, but he has, my lord, kept the ganja. Your lordship may kindly see the rejection order.
He was not
Yes,
there.
with the counseling position, thereafter the police got and 155 kg of ganja has been seized, my lord.
What are the allegations against him? Against him?
My lord?
Against him, what are the allegations?
51.
No specific allegation against him.
Come to the charge sheet.
My lord?
Charge sheet, your lordship.
What is your name? Name is?
Joan
Name is John
Gomango.
John Gomango.
My lord, I reside in the police station at R. Udayagiri. I don't stay there. I don't stay in that house. I have my wife is a teacher and I am a home guard. I stay in a different place. This place belongs to the place where the seizure has been made, belongs to our ancestral property, which is registered in 3 brothers' name. I have been only implicated. And there are other procedural lacuna, but that I will not press right now.
Yes.
Your lordship may kindly consider he is already in custody for more than 1 year and 4 months.
You are arrested from the spot.
No, my lord. That is what I am saying. I was not there. I don't stay there. My wife is a teacher and I stay at R. Udayagiri. I don't stay there. That is.
By John Gomango.
In the last round, your lordship said that let 1 year complete, then your lordship would kindly consider.
These type of
How have you arrived at the conclusion that John Gomang has kept these?
That is the point.
What are the materials?
His house, that is, he belongs to his
House, the other brothers are also.
That is not the investigation that does not disclose that other.
If you don't write it, ancestral property. And what are the connecting? Any evidence you have that he has kept it? Any statement of any witness or anything? The IO says that he has kept it, doesn't mean that he has kept it, unless you get some 161 statement, show me. Any witness have said that I've seen bringing or something of that sort.
1 PM,
Nothing is there.
1 PM is the seizure is being made in a village and no independent witness are there or police witness.
I can understand if you arrest him from the spot.
My lord.
He's not even arrested from the spot. There is no 161 statement. What else? 1 year custody. And he is a police guard and he will not. Morally he shouldn't do, but the fact is bail, he has to appear. And what is the connecting material? You tell me. If you have a connecting material, I'll reject it. Huh?
My lord. Last again.
And you show me, you have said that John Gomango has kept this contraband in the house. Where is the statement? From where?
My lord.
The IO goes, raids the house, and he found 250 kg?
No, 150.
150 kg of ganja. And he decides there that no, he has kept it.
The house belongs to 3 brothers and I'm not there even.
Do you have anything? I'll grant bail.
That is the case.
I'll grant bail.
Obliged.
There is nothing. I know. Petitioner is accusing so. Sorry, obviously. You have to open it. Allegation of petitioner. So. Dismissal also for the petition submits that except submits that the petitioner was arrested after 1 year.
My lord.
After the FIR was registered on 10/3/2023, and the petitioner was arrested on 9/8/2024. Perusal of the charge sheet reveals that there is no connecting evidence to establish that the contraband was kept by the accused in the spot. The only allegation is from the spot, from the house,
in the kitchen room.
belongs to the petitioner. The contraband ganja of 150 kg was seized. The petitioner is not even appearing from the spot. Mr. Mishra and counsel for the petitioner submit that the house is the ancestral property of the petitioner and his brother.
Two brothers.
Two brothers. I have perused the charge sheet and connected document form part of the charge sheet. Nothing is coming on record to connect the petitioner, connect the claim of the prosecution that the petitioner has kept. Petitioner has parked the contraband in the house.
Kitchen room.
And then consequently the state vehemently opposed the bail in view of the fact, in view of the quantity of contraband ganja seized, and he submits that the petitioner is the home guard.
No.
Petitioner is the home guard, and the involvement of the petitioner in this kind of case is
And his kitchen room that has been seized. And his kitchen room that is
is to be serious, is to be viewed seriously, and therefore is not entitled to bail. Regarding, and I have perused the entire record, I am of the opinion that the petitioner is entitled to bail in view of the fact that there is no conscious position. Conscious position of contraband seized from the petitioner. Petitioner is arrested after 1 year of the alleged FIR. He is in custody since 9/8/2024. Regarding that to the period of custody and nature of acquisition, yes, with all conditions. Yes.
Obligement.
Yes.
49 or 21C of the and 29 of the NDPS Act, and the fact remains well at around 5,520 Wintex cough syrup has been found from the possession of the petitioner, and who was also standing there. Earlier,
Your Lordship has granted some persons bail and also rejected bail of some accused persons. On the ground, those who have managed in the spot, your Lordship has rejected, and the persons who are not there in the on the basis of confession.
They have granted the bail. Yes.
So, skater is not there. Versus keeping
No,
because must be there in the skater must be here.
I have a submission, madam. And first, it was disposed of on the ground that charge sheet was not submitted, thereby giving liberty to the petitioner to move the Hon'Ble landed court if something in the charge sheet. The fact remains when admitted that during charge sheet, at the time of filing the charge sheet, chemical exhaustion report was not there. And this Hon'Ble court, my lord, has passed an order wherein directing the concerned persons to approach the concerned court below in view of the fact that chemical exhaustion report has been not submitted, and taking note of the coordinate bench judgment, my lord. So may I pray, my lord, dispose of this application with the same limit? If it has been filed, definitely I have to again go up.
Sorry, you have the Then he will tell this spot he will not there. Then
No, spot second matlab because I have come up with this honorable court and Marital may given liberty in the earlier application, the exact word. If such an application is moved, the same shall be considered by the trial court.
What was that case?
Yes. Chemical examination report was not filed at the during charge sheet, and the Nile court has taken cognizance in the absence of the chemical examination report, my lord. So my humble submission, unless and until chemical examination report will come, which specify that yes, in fact, the particular
In this case, chemical analysis report is there.
No, not right. That's why my humble submission.
Charge sheet is not there. Because first time it is come.
Next week, just check it up. If we see his report is not there, and what he says that
for that reason I am paying for next week because CD.
That's what I'm keeping it. But just see this. Is a fair.
Past some cases in order.
This is a fair order. He will repeat it.
Yes.
And the court has to decide in the light of.
I will take it on Friday.
Because if you.
Friday as well.
Okay.
Friday.
Friday or Monday?
Monday.
Okay. Yes.
On behalf of Ms. Naidu, kindly taken up from other time.
Okay. And request check, please.
51.
No. Password. Okay. 51. Okay, pass.
52. Your Lordship, I am in custody before January 2024.
Sorry?
January 24th, 2024. I am in custody.
There are three applications. First application, my learned friend is there. Second application, my learned friend is here, and I am in third application. My petitioner is having the serial number 3. Third application is mine, my lord.
Okay. Then you are in third application, huh?
Yes.
Okay.
And I am in the second application, Lordship.
Yes. Then argue second application.
My lord.
Let us see.
My lord,
all of them are custody from same.
Custody, my lord, 22/4/2024.
My custody, my lord.
2024 in third application.
My custody.
2024.
My custody date, my lords, 25/4/2024, my lords.
25/4/2024. Okay.
My lords, charge sheet has been submitted on 14/5/2024, my lords, for offence under section 419, 420, 465, 467, 471, 123, 34 IPC, and section 66C and 66D of IT Act, my lord.
What are the allegations?
My lords, allegation is that the informant, none of the petitioner named in the FIR, my lords, unknown FIR, allegation by the informant that he received a telephonic message, my lords, WhatsApp call from one Sapna lady person, my lords, inviting him for some informant was asked for some amount to continue that account, and that portal manager, my lord, they said that your account has been blocked. So to unblock this account, you are required to make some payment, my lords. So at different stages, the informant allegedly makes some payment, my lords. So different persons, my lords, and my lords, basis or implications about the my petition is
Sabiuddin Khan.
My lords, is the confession of co-accused Amanullah Khan, my lord, the petitioner in the first application, my lords. And total financial liability, my lords, as per FR is 25,93,200 odd, my lords. Out of which liability against the present petitioner is 5,98,000, my lords, who is the petitioner is ready to secure, my lords.
How many cases are there against you? That's important.
The period was completed 25/24. And there are 24 numbers of complaints. For that purpose, Millard, so we have serious objections to Millard. Every day, Millard, they are asking for some.
No, but see, you last time I rejected your bail application saying that you are involved not only in Orissa, across the country you have been doing.
But there is not a single. The father of the petitioner has filed an affidavit, Millards, indicating that petitioner has no pending cases against him. Lordship, kindly say, Millards. There is no FIR registered. Not a single FIR has been registered.
It is alleged that petitioner is involved in many other cases across the country.
They are saying that allegations, no FIR, my lord. Lordship kindly see. No FIR as on date, my lords. They are saying only allegations.
And there are 24 numbers of complaints now
Yes.
in India, and we have collected documents also.
He is filing affidavit, just check it up.
Name
My
as
lord,
charge sheet
also for the state submits that the IO of the case is inquiring about the antecedent of the petitioners. Petitioner. He submits that to the there are as many as more than 20 complaints, more than 20 complaints are pending across the country. He is collating information regarding the same, hence seeks an adjournment, leaves the matter after we.
My lord, in my case, my lord, he is a MSc student, my lord. If your lordship have a
How
plan-
many cases are there again?
No case, and I have already.
But he
My lord-
says, Praveen Kumar?
No. My lord, kindly see, your lordship has gone through this affidavit earlier.
They are only
And my case was not rejected.
Filed it.
My case was not rejected any time earlier, my lord. And only 50,000 rupees have been sent to my account, my lord. Only 50,000 rupees, and he is a MSc student, my lord.
And my petition is ready.
And your lordship has seen this since 12, I think.
12?
24, I think.
We'll verify this. Verify it.
Well, I have supplied already.
Verify it and tell me. After 1 week to 2 weeks.
Next week, your lordship may say.
Next week, my lord.
Because last date, my lords, your lordship has directed to know what the modus operandi of these petitioners.
It's
And
very
for-
difficult to know because these people are
For that,
across
my
the
lord,
country, they are
for
doing
that, your lordship has directed to remain directed the IO to remain present. My lord, 50,000 I am ready to pay, my lord.
It's not 50,000. You have
No.
Many people.
Another interesting thing is the person who has sent to money in my account is Binod Patra. He is not the informant here. He is not one of the
maybe.
exhibit
See, I'll
persons
tell
in
you
this case
the
even.
kind of modus operandi adopted by these people. It's very difficult to.
My lord,
nab
for
it.
that, my lord, your lordship has
Because the
directed.
investigating officers are not well equipped. They don't have
Your
knowledge.
lordship has directed the IO to
Private
remain
crime.
present. Your lordship has directed the IO to remain present on 24th of this month.
And you have the own experience. Everybody has the experience in the court. Every time you get the phone call and your money goes.
My lords, one prayer.
The moment you click it.
Your lordship.
This is how they do it across the country.
Lordship kindly fix a short date
Yeah,
and
I'll-
make it the
Let
final
it-
disposal, my lord. No further adjournment, my lords. Lordship
Yes,
kindly
next.
for final disposal. no further
As per their pair on 10th of January, the case was posted to 24th.
Had it been an isolated case, here and now I would have given it. But I want to know across the country how many cases you have.
Hot date may be fixed so that.
Charge sheet May Masuri charge sheet they do not have any single FIR number with them.
By each day, my lord, the councils are changing. My learned friend is saying like this today. Last date.
So
Don't change the government next time.
Lordship kindly
short date. Ma'am.
Yes.
So Lordship give it a last chance to the Lordship.
Last chance.
Next.
Yes.
Next. One minute.
There is a delay of
53.
my lord.
53.
It's a delay of 2,187 days delay, my lord. The litigation was dismissed, my lord, for not taking steps for substitution in time. After this, they are dismissed, my lord. Yes. When the matter was taken up in the trial court, the opposite party came and I came to know that the trial was beginning in the lower court. The petition
This is 53.
regarding a remote village.
52 or 53?
53.
53.
53.
Okay. Huh? Bail complete. Okay. I was just wondering. Yes. Yes, sir.
There is a delay of 2,187 days, my lord. The requisition was dismissed, my lord, for non-taking of steps for substitution. In time, my lord. Thereafter, the case was not taken up, my lord.
Representing the original opposite party number 1 died from so and the step to What is the explanation? See, delay is how 1,000?
2,187.
2,100?
87 days.
What are the explanations?
Explanation, my lord. After the dismissal of the writ petition, we could not know about the dismissal. Perimeter order was passed. Thereafter, we are even do not know the status of the case. When the matter was taken before the trial court about the restoration of the land by the opposite party, he came to the court. I came to know that. Thereafter, we.
What kind of writ petition you had filed? 98 the writ petition was filed. Today we are in 2025. You want restoration of that?
Yes.
If you have a fresh cause of action, file a fresh writ petition.
If cause of action.
If cause of action.
May issue notice on the question.
No. There is no explanation. Right. I will give that liberty. You revive. You file a fresh petition. Okay. I know. Petitioner is in this petition is seeking restoration of OJC number 14025 of 1998, which was dismissed for non-prosecution by order dated 11/9/2018. The present petition suffers a delay of 2187 days. 2187 days. To explain the delay, the petitioner has petitioner in the application has stated as under para 2 and 3. Para 2 and 3. The explanation offered by the petitioner to explain the sufficient cause preventing him from filing the restoration application is not sufficient. Hence, I'm not intending to condone the delay. As a consequence of the same, the CMP is dismissed. However, dismissal of the present petitions will not preclude the petitioner from filing any other from resorting to any other remedy available under law if cause of action still survives. Yes.
Case was dismissed for default.
Yes.
Ma'am. Yes, sir. The case was dismissed for default only because of the absence of the advocate.
Yes.
It was filed in time.
What is the delay?
No, don't
No
delay.
delay. For the reasons stated in the application, the same is allowed. The CRLMC number 561 of 2019 is restored to its original file while setting it while recalling the order dated
31/3/2023.
Please the matter in equal course.
And for the appellant.
Is there anything survives there?
Yes, ma'am. That is
What
there.
is that?
A person, well, the fact of the case is also very. A lecturer filed a appeal before the director against the termination, but her appointment is initially bad because he didn't have the position of the MA qualification. That is why the appeal once he could have managed to get an order from the appellate authority. Immediately, management has the secretary is here before my lord. Secretary has filed a writ petition and it was stayed. Thereafter, when she insisted for joining, and that is why he filed the affair. And finally, my lord, again after remand, also 22, the appellate authority has found that she has no qualification. Appeal was dismissed, and he is not challenging that order. That's the case.
Yes.
55, my lord, I am for the appellant. I filed one interim application for condonation of delay. There is a 66-day delay, and matter can be disposed of, my lord. Delay may be condoned and.
Yes, ma'am. For the reasons stated in the application, delay of 66 days is condoned and main effect.
And another IA, my lord, have filed the receipt showing for paying time for filing of the receipt showing default of the ordered amount.
already filed, my lord, that I may be also disposed of.
Which one?
That has not been.
What are you
from-
asking?
filed-
Dispense with?
No, I have already filed the deposit of receipt. Restitution deposit, I don't before the commissioner.
You have
That-
deposited, na?
Already deposited.
ठीक है.
My lord.
Council, आयर तो लिखा ही थी ना?
I number होची 84
No, no.
of 25. No, sir, separate.
Have you said that you have deposited?
Yes,
No?
yes, already deposited.
You have said?
Yes.
Oh, forget about that.
Obliged, sir.
Yes.
56.
56.
also can be disposed of.
Appearance लगा दी थी ना? Didn't appearance. 56.
I my lord.
Same.
For time to, my lord, to file
I-
a deposit slip.
IA for?
Time to file deposit slip, I am filing there.
For the reason,
I will be disposed of.
for the reason stated in the application, the same is allowed. The receipt for deposit for the compensation amount before commissioner, huh?
Yes, my lord.
Before commissioner, it's taken on record, huh? Taken on record. And may not. ठीक है.
Another I for condemnation of delay.
Condemnation for same लिख दो, for reason stated in the application. Delay of
Delay of about 61 years, according to my calculation. 61 days, my lord, sorry.
don't say yes.
Sorry, my lord, sorry.
61 days, okay. Done.
No, can we dispose of?
Dispute.
Dispute.
हाँ, लिख के आप correction कर दीजिए, ठीक है. Yes.
Time required. Point of law is involved in this case.
Point of law.
My lord, there is a delay of 67 days delay. The delay may be condoned and interim order to
Point of law, I'll keep it open, argue in some other case.
Yes, madam.
I will
Yes,
list it up. What do you say?
He is praying for time for
I
year.
will obtain some
What
discussion
happened,
in support of my
my lord,
application.
in the particular case, award amount will shifted to the owner of the vehicle because the deceased person was driving the vehicle had no DL at the time of accident. In view of the judgment of the Beliram, in case of the Supreme Court, that will shifted to the insurance from the insurance company to the owner. He is trying to obtain the order after some days, for which he is praying time.
Simply additional कर दो on the request. Okay.
Well, delay may be condoned. 67 days delay may be condoned.
Like condone?
Yes, ma'am.
Okay. For the reasons stated in the application, delay in filing the AP, for first FAO is condoned. Delay of 61 days.
67 days.
67 days is condoned. And let counsel for the opposite party seek adjournment to address the court on the appeal. Easy matter. Yes.
Interim order to continue.
Interim order to continue. Yes.
Kindly pass over item 58.
Pass.
59.
$59. Pass.
60.
My lord, IA for extension of time. Here is petition number 1 is arrested and in the custody.
Extension of times?
For petition number 2 and 3. And in the last order, your lordship was directed to surrender it to the last chance. So my prayer is,
No further extension shall be granted. It is written.
they are ladies and in-laws. I'm
Huh?
praying for last.
If I've said no further extension, no further extension.
15 दिन के हैं. They are in-laws.
This is for petition number 1.
Petition number 2 and 3.
2 and 3, you have already sought one extension.
My lord, petition number 1 already
No,
arrested.
I can't give indulgence like this.
15 days, my lord. They are in-laws and they are staying away from.
What are the offenses?
It is 304B and 498.
Of them? The NBW was issued, I cancelled it, I asked you to appear, you didn't appear. The date was given when? The earliest the date was given?
Any cost, my lord.
30th June 2024, you didn't appear. Ask for extension. Again, I extended up till September. Didn't appear. And there is already it is written that it is made clear that no further extensions shall be granted. Again, you are asking for.
But the cost is last.
Show me what is the reason. Show me what is the reason.
They are LADs and in-laws. They are.
Show me the reason. You have to give sufficient reason for extension. I can't do that. Yes.
The petitioner 2 and 3. They are in-laws of the.
Show me the application. What is the reason of not surrendering?
In the para 3.
Para 3.
My lord.
Yes, tell me.
But in thereafter, the petitioner 2 and 3 could not surrender in the time. By then, they were residing in their relatives' house, in-laws.
Para 3 of which application you are reading?
In the IA 273.
273. Para 3.
Hmm.
Para 3 or 2?
Para 2. Last line.
Is this a ground? They were staying in in-laws' house, therefore they will not come. Can I impose cost?
Any cost, my lord?
2,500 each for the right on. The petitioner by order dated 25/4/2024. What is that? नहीं 20 sorry 20/5/2024. 20/5/2024. The petitioner was petitioners were petitioners were directed to surrender before the court.
Petitioner 2 and 3.
Petitioner 2 and 3. Petitioner number 2 and 3 directed to surrender before the court on or before 30th June 2024. 24 and resort to the remedy available to them under law. The petitioner did not surrender as per the direction of this court and moved an application being IA number 1980 of 2024 seeking further extension. Regarding head to the ground stated in the said application, the court by the order dated 28/8/2024 extended the time for surrendering up till 15th September 2024 with a caveat that no further extension shall be granted. The petitioner has now moved the present IA, present IA number 273, 273, present IA, present IA seeking further extension of time. The further extension of time. The reasons stated in the applications are not sufficient for the excuse from not surrendering pursuant to the court order. However, the counsel for the petitioner submits that last and final opportunity may be given to petitioner number 2 and 3 to surrender before the court without bail. He further submits that the petitioner number 1 has already been arrested. The counsel for the petitioner submits that subject to any condition, the application may be allowed. Regarding head to the submission made by the counsel for the petitioner, the bar, and the reasons stated in the application, by way of last and opportunity, the time is extended up till 5th of 28th of February. February, the petition number 2 and 3 are directed to APS surrender before the court below on or before 28th of February without fate, and subject to paying a cost of rupees 5,000. To be deposited where? No, yeah, I'll give who is the victim here.
GMFC Commission General.
Victim is not included. Which bar is this? Nagar, Punjab. High Court bar.
GMFC Commission General.
High Court bar, huh? High Court bar.
Petition 2 and 3 both 5,000.
It is made clear that at no circumstances the circumstances further extension shall be granted to the petitioner. Petitioner.
5,000 both.
Hmm?
Both the petition 5,000.
Yes. You want to pay more, then I can try. Okay. Here, the problem is if you don't allow, they'll ask an NBW will issue. Again, he'll come for cancellation of NBW. That's another problem. So better, yes.
61.
Yes, correct address I already filed. My resolution was special machinery.
Opposite party number 2.
I am petition number. Opposite party number 2, correct address already filed.
Without any answer.
Only special machinery.
Special machinery. Yes.
62.
Lordship direct to release the amount within 2 days, but since it did not mention in favor of the other way to.
DD number?
It did not mention for the officially the darkness and the.
Which one? Which order you are talking about?
I am not telling the order, but Lordship allowed the opposite by to release the amount DD. Page 11 of
Yesterday.
so much, one motion.
Shall be released in favor of opposite party number 2.
Yes, Lord. But since DD not mentioned, but the.
Okay. Where is that DD?
The case.
There, na?
And the opposite party is physically present also
But-
allowed to hold
okay,
it inside the court.
Pursuant to the order dated 20/1/2025, the demand draft number so and so lying in this court record could not be released in favor of opposite party number 2.
Opposite party is physically present.
Hence, he has moved. She has moved an application. Opposite party number 2. He has moved an application for release of the demand draft in her favor. In her favor. The application for the reason stated in the application, the same is allowed. The DD number so and so, dated number so and so, dated so and so, drawn in favor of Manjulata Naik, the opposite party number 2, is released. Released in that favor. Photocopy of the DD along with the receipt of the same shall be placed on record. Photocopy will give you. Shall be placed on record by the counsel for the petitioner. Sign kori de diye. Photocopy sign kori file kar do. Pretty good actually. The office is directed to release the draft during the course of the day.
Because they only expired very shortly, because that has done 11/11.
Today only you take it and just I'm sending the to the section immediately for the sorry. DD number वगैरह दे दो अच्छी नहीं की दे दियो तो साइन करके आज ही नहीं जाओ ठीक है
Item 63 on behalf of Mr. S.K. Adipati, notice issued to opposite partner return answered. I will file the consolidated.
63.
I will file the consolidated corrected cost title by tomorrow. Will also issue notice.
Notice was issued to opposite party number 2, but due to want of address, the same could not be served. And counsel for the petitioner seeks the judgment to file the consolidated file press address of opposite party number 2, BC matter on Shons. Yes.
Entry mode to come.
Entry mode to come.
ନାଁଟା ଟିକେ ଭୁଲ ଶୁଭ ଲକ୍ଷ୍ମୀଜାର ଶୁଭ ଜାନି ହବ ନାଁଟା ଟିକେ ଖାଲି ଭୁଲ ଅଛି
Yes, yes. Okay.
64 my lord, extension of time error.
64.
Extension of time.
चलो extension of time कर दिया extension of time.
Page formality, your lordship directed the cattle are to be released within 1 week from today on deposit of rupees 2 lakhs. My lord, due to local holidays, the petition could not be released.
Extension कर दिया 2 weeks.
My lord, 2 weeks.
For the 2.
Oblige.
This is a conversion matter actually.
Which one?
66.
Yes.
Delay condemnation it has come. I'll serve the copy extra because it was earlier served to, yes, it was served earlier.
So what do you want?
Well, delay may be condoned. The other defects pointed out by the registry, I'll remove it.
He just give the copy immediately after lunch.
CRLMC it was given, but you are also directed to convert it because.
Give a copy at 2 o'clock, I'll take it up. Yes.
Two thousand and 24, the consolidated petition office has appointed the no consolidated CRLM's petition not yet been filed. Today they filed the consolidated petition. Copy the
Today you are filing.
Lordship.
Today you are filing.
Consolidated cost title. Office has appointed.
You have to file it there.
Sir, it पड़ेगा सब लोगों से सेटी number
Pursuant to the order dated 16/12/2024, the petitioner is filing the consolidated memo of amended memo of parties. Let it be taken into court, lease the matter. Yes. Next.
Copy served.
Yes.
25.
Date, your lordship, date may be, your lordship, date may be fixed.
Second round litigation.
25.
But admittedly, there was no eyewitness to the occurrence. Initially, one UD case was registered. While the UD case was registered against unknown person, the police investigated the matter, and accordingly, the accordingly the IO of the case, basing upon a sniffer dog, caught one Gagan Jagdala, and subsequently the petitioner was added as an accused. In the meantime, charge sheet has been submitted and the case has been submitted to the Court of Sessions.
Yes.
Your lordship may kindly see.
Preliminary charge sheet was filed. Thereafter, on 19/11/2000, supplementary charge sheet has to be filed. He has prayed for time to further investigation.
So let it be filed.
In the meantime, the case has been committed to the Court of Sessions for trial. Your lordship may kindly see.
On 29,
My name does not find place in the FIR. Basing upon the own confession and basing upon the confession of one co-accused, Rajkishore alias Gagan Jagdala,
Yes.
the petitioner is in custody. And the offense under section 302(201).
Custody since?
Custody since 11/3/2024.
Yes.
Your lordship has directed after submission of charge sheet.
No, I only say that time the charge sheet was not
filed, but
charge sheet.
in the meantime, charge sheet has been
He
submitted.
says that preliminary charge sheet is filed.
Preliminary charge.
Preliminary,
And supplementary charge is yet to be filed.
but commitment has been made. The preliminary charge sheet has been submitted.
Show me.
This is
Open, keeping investigation open in respect of others.
Yes.
Charge sheet has been submitted on dated
Show me the order.
302(201)120B34 by
Yes, I know.
charge sheet number 77/2007.
Yes. Have you prepared on merits?
I thought that the matter has been adjourned, therefore I
List it after one. Yes, next.
26.
26 CD is there. POXO is there.
CD, okay. Yes.
Or that, if possible, 20 or 21st.
We'll give it, yes.
38.
38 matter. This is second round litigation. In this case, the petition has not been named in the affair. Last time, it was Whitson directing the petitioner to move the court below. At that time, 7 witnesses are examined. In the meantime, 8 witnesses have been examined, and nobody has whispered the name of the petitioner.
My lordship, kindly have a glance to the 164 statement of the informant.
Yes. Samir Mahalinga.
May
Okay, 164.
Yes.
Read it.
ମୁଁ
Read it.
ଦିନ ପରେ ଫେରାଇ ଦେବି ବୋଲି କହିଥିଲି। 3/1/2024 ସକାଳ ମୁଁ ଶ୍ୟାମଦନ୍ତା ମୋଟରସାଇକେଲ ମାଗିକି ନେଇଥିଲି। ସେଇଦିନ ଉପର ବେଳା ଶ୍ୟାମଦନ୍ତା ସମିତ ମହାଲିଙ୍ଗ ଓ ଚୈତନ୍ୟ ମହାକୁଣ୍ଡ ମିଶି ଆମ ଗ୍ରାମକୁ ଯାଇ ମଦ ଖାଇଯିବା ବୋଲି କହି ମତେ ମୋଟରସାଇକେଲରେ ଦପଲା ନେଇ ଆସିଥିଲେ। ସେମାନେ ମୋ ଶ୍ୟାମଦନ୍ତାର ବାଡ଼ି ପଟେ ଥିବା କପା ବାଡ଼ିରେ ରଖିଥିଲେ। ଏହାପରେ ସେମାନେ ସେମାନଙ୍କ ସାଙ୍ଗ ମନୋଜ ଦନ୍ତା, କୃତିବାସ ପ୍ରଧାନ ଓ ଶ୍ରୀତମ ମହାକୁଣ୍ଡକୁ ସେଠାକୁ ନେଇ ଶ୍ୟାମଦନ୍ତା ମୋ ବେକରେ ଛୁରୀ ଲଗାଇ ଟଙ୍କା ନଦେଲେ ଜୀବନ ମାରିଦେବେ ବୋଲି ଧମକ ଦେଲା। ମୁଁ ଉପାୟରେ ମୋ ସ୍ତ୍ରୀକୁ ଫୋନ କରି ଟଙ୍କା ଆଣିବାକୁ କହିଲାରୁ ମୋ ସ୍ତ୍ରୀ ଟଙ୍କା ନାହିଁ କହି ମନା କଲା। କିଛି ସମୟ ପରେ ମୋ ଶ୍ୱଶୁର ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ପ୍ରଧାନ ମତେ ଫୋନ କରି ପଇସା କେଉଁଠିକୁ ନେଇଯିବ ପଚାରିଲେ। ଚୈତନ୍ୟ ଓ ଅନ୍ୟମାନଙ୍କ କହିବା ଅନୁସାରେ ମୋର ଶ୍ୱଶୁର ମୋ କଥାରେ ଦପଲା ହାଇସ୍କୁଲ ପାଖକୁ ଆସିଲେ। ଚୈତନ୍ୟ, କୃତିବାସ, ମନୋଜ ଓ ଶ୍ରୀତମ ଟଙ୍କା ମାଗିବାରୁ ହାଇସ୍କୁଲ ପାଖକୁ ଗଲେ। ଶ୍ୟାମ ଓ ସମିତ ମତେ ଜଗିଥିଲେ। ମୋର ଶ୍ୱଶୁରଙ୍କ ସହିତ 5-6 ଜଣ ଲୋକ ଆସିଥିଲେ। ସେଠାରେ ମୋର ଶ୍ୱଶୁର ଓ ଚୈତନ୍ୟ ମାନଙ୍କ ମଧ୍ୟରେ ଯୁକ୍ତିତର୍କ ହେଲା। ଶ୍ରୀତମ ଆସି ଶ୍ୟାମ ଓ ସମିତକୁ ଡାକି ନେଲା। ମୁଁ ସେଠାରୁ ଖସି ପଳାଇଲି। ମୁଁ ଧଇଁରାକୁଦ, ବେସପାରି, କୁଳିଆପାଲି, ଲମ୍ବସାରି
364 is also there.
Yes, my
This one, কিন্তু Samit Mahalaga not there.
Is there?
Yes, my lordship.
His
His
name?
name is witness is Parameshwar Mahapun, who is gone with his father-in-law
Forums
by
for
taking the money, my lordship, 1 lakh money.
Forums for Mahapur.
Has he been examined?
No, forums for, next week I think.
Yes.
8 witness examined.
2 weeks. Yes. Next.
51.
For alleged offence, my lord, 326A 506 by 34 of the IPC, custody more than a year, my lord. Statement of the victim, the lordship, turn to page 13.
13.
Yes,
Who is
ma'am.
appearing first? Ready? Yes. 1-3.
1-3, my lord.
Yes.
The statement of the victim, my lord. ମୋର ନାମ ରଞ୍ଜନ ଲିମା ୱାନ୍ସୋ ଏଇସଙ୍ଗେ ସାର୍ ବୟାନ ନେଇକି ଯେ ମୋର ପ୍ରଥମ ସ୍ତ୍ରୀ ମରିଯିବା ପରେ ମୁଁ ଆମ ଗ୍ରାମର ପିତରପାଲଙ୍କର ଝିଅ ପିତରପାଲ ଇଜ ଦ ପିଟିସନର ସୁଶାନ୍ତ ବାବୁ 3 ବର୍ଷ ହେବ ସ୍ତ୍ରୀ ଭାବେ ରଖି ଆମର ଘରେ କିଛି ଦିନ ଶ୍ୱଶୁର ଘରେ କିଛି ଦିନ ରହୁଥିଲି ମୋର ପ୍ରଥମ ସ୍ତ୍ରୀର 3 ଗୋଟି ସନ୍ତାନ ଅଛି ଦ୍ୱିତୀୟ ସ୍ତ୍ରୀର କିଛି ସନ୍ତାନ ନାହିଁ ମୁଁ କୁଲି କାମ କରି ପରିବାର ଚଳାଏ ଗତ 29/1/2024 ତାରିଖ ରାତ୍ର ପ୍ରାୟ 7 ଘଣ୍ଟା ସମୟ ମୁଁ ମୋହନାର କାମ ସାରି ମୋର ଶ୍ୱଶୁର ଘରକୁ ଫେରିଲି ତାଙ୍କର ଦାଣ୍ଡ କବାଟ ବନ୍ଦ ଥିବାରୁ ମୁଁ ଉକ୍ତ ଘର ବାଡ଼ିପଟ ଗଲି ସେଠାରେ ପହଞ୍ଚିବା ପରେ ମୁଁ ବାଡ଼ି କବାଟ ବାଡ଼ାଇଲି ମୋ ଶ୍ୱଶୁର ପିତର ହଠାତ୍ ରାଗି ଯାଇ କବାଟ ଖୋଲି ମୋ ମୁହଁରେ ପାଡ଼ି ଦେଲେ ମୋ ସ୍ତ୍ରୀ ସୁଶାନ୍ତ ପାଲ ସେଠାରେ ଥିଲା ଜାଣିଥିଲା ମାତ୍ର ସେ ମୋ ଶ୍ୱଶୁରଙ୍କୁ ସେ ଫୋପାଡ଼ିବା ବେଳେ ମନା କଲା ନାହିଁ ଫଳରେ ମୋ ଆଖି କୋଡ଼ରେ ଚଳାପଡ଼ା ହେଲେ ଏଣୁ ମୁଁ ନିଜର ଜୀବନ ବଞ୍ଚାଇବାକୁ ଯାଇ ପାଟି କରି ଆମ ଗ୍ରାମର ଜୋନ୍ ଘରକୁ ଦୌଡ଼ି ପଳାଇଲି ସେହି ଘରେ ଜୋନ୍ ପାଳଙ୍କ ପୁଅ ବାବୁଲା ପାଳ ଉପସ୍ଥିତ ଥିଲା medical 1 grievous injuries and more than a year he is in custody.
Show me the medical. Yes. Medical.
Charge sheet submitted, 1 grievous injury. He has L&T and moving in the village. Statement was recorded.
Including
petition is the father-in-law. Injured is the son-in-law.
No, the burn injury in his face, including the left eyes, left arms, and left leg. The injury in eye is grievous in nature.
Aye.
But whether visibility in the
Yes, yes. He is moving in the village. He is the son-in-law. His petition is the father-in-law.
All right, but visibility is affected.
He was moving in the village, my lord. More than a year, old man is in custody. 326.
You get the instruction whether his visibility is affected or what? Tomorrow? Next week. If the visibility is not affected, he is entitled to bail.
At 326, more than a year he is in custody. Tribal magistrate, my lord.
I know 326, but see the visibility.
1 year he is in custody. Old man. I see. Acid, no, acid pani jo.
Stage of the trial. Stage of the trial.
সেইটা instruction নাই tomorrow my lord
charge has been framed
hey
charge has been framed Monday just tell me that much if we
obliged
8 What is this matter?
Lord, just for it, where the drug under the Drug and Cosmetics Act, the offences were supposed to be committed, but the action has been initiated under the IPC. And apart from that, the procedural aspects so far as the Drugs and Cosmetics Act have not been followed. So, Lord, the interim arrangement, your Lord says 27/5/24.
Interim arrangement to continue.
Yes.
At the request of the council for the state urgent, release the matter on sunset. Yes.
Short date.
Interim order to continue.
Lots of can fix up any date.
Yeah. Where I can hear it. Okay. Yes.
59. Item 59 on behalf of I pray for an adjournment, madam. Interim order to continue, madam.
No, that is why you are asking for it. Mr. Chand was here.
He is out of station now, my lord. He went to Bhubaneswar, madam.
Pay cost, huh? Pay cost to the bar, 500, at least 500. I will adjourn it. Adjourn it. Interim or to interim. What is the interim arrangement? See, 1, 2, 3, 4, 5, 6, 7, 8, 9 dates.
This must be the last.
You have taken interim order, and thereafter 9 days you have taken. This is why the interim orders are not being passed. On behalf of Mr. Chand, an adjournment is sought. In the best of justice urgent to so and so. The interim arrangement made on which date? The interim order. The interim order passed earlier. Shall continue subject to petitioner depositing rupees 500 in bar, High Court bar. Yes.
65.
$65. What is this matter? Hmm? Yes. It has already been disposed of 125 proceeding. That by daughter dated petitioner has moved the present application making out a grievance that his her application under section 125 CRPC seeking one CRPC being a criminal being criminal proceeding what is that? Criminal proceeding being criminal proceeding numbers 632 of 2007 is pending since 12/11/2007. Hence, he sought the indulgence of this court for a direction for early disposal of the same. By the order dated 23/12/2024, this court has sought for an report from the trial court regarding the status of sought for a report and directed the court below to dispose of the application as expeditiously as possible, preferably within a period of 6 months. Pursuant thereto, and report dated 25 has been by the family court Cuttack has been placed on record. The report reads as under. Report reads as under. in view of the aforementioned report, nothing survived in the present petition. Accordingly, it is disposed of. Yes.
66. Providing me with the copy notes.
Another copy.
Introduction about the application. Formulation today's listing for.
Acha. For the reasons stated in the application, the condemnation are for delay in filing the revision.
He has filed an application.
Revision. I understand. Converted revision petition. Being criminal revision 597 of 2024 is condoned. Condoned. Let us come to the revision now.
On merit, lordship,
Merit, are you ready?
Allegation is.
No, I understand the point because, but I will take some instruction.
Okay.
Because the instructions there in the CLM.
Okay, issue notice on the revision. Yes.
The lordship fixed it as early date because trial.
Yes, yes. Take.
Next day, take up this matter next week.
Next week.
Discharge petition. A very peculiar case. There is absolutely no case made out against him.
Let us see. We just give a short date. Wait. Yes.
Judgment under review, that's a little incomprehensible to me. The fact is like this, my lord. I sold 3.15 decimals of land.
Anybody, you are appealing?
They only one thing is an order dated 15th May 2024. Let my lord friend take instruction regarding the status of the.
The status I have ascertained today.
My friend is to take this report in respect of the order. Because
No, nothing has happened. I know.
For maintenance of the record and for the prior initiation of section 9 applications. My lord friend is to take the instruction.
Nothing has happened. Nothing has happened because this review has been filed with intimation to the officer concerned. So nothing has happened since this review is pending.
Yes.
I sold 3.15 decimals of land measuring A into B. Now, during the operation, settlement operation, what happened was consolidation operation, 4 decimals got recorded in favor of the purchaser. So I filed an application before the consolidation officer for correction of the record.
Yes.
That was allowed.
Hmm.
It was confirmed in appeal before the deputy director.
Yes.
A revision was carried. Revision, it got reversed. Against that, my learned friend's client came up before this honorable
in the
court.
writ.
In the writ petition. In the writ petition.
My lord friend's client has come for the writ application.
Yes, yes. You have come. You have come.
Yes, sir. Since the revisional authority had reversed it, I had come before the High Court, challenging the revisional order. Now, if your lordship sees the impugned order, what has happened is all the 3 orders have been set aside.
But the revisional order is a consequential order.
Consequential order. He has set aside the revisional order, the appellate order, as well as the consolidation officer's order. So that is what the review is for. If your lordship sees,
yes,
a little incomprehensible. Para 5.
What is the net effect of this order then?
Net effect is that I have sold 3.15, 4 decimals remain recorded in his name.
Okay. Then it has to be set aside and send it back.
Remitted back to the revisional authority.
You lordship kindly see paragraph 6.
6 up for the review.
No, original
Order. Okay. Yes. Considering the rival.
Considering the rival continuation of this court on perusal of the court, I should have filed the review because this order I should have filed the review, but I have not filed. Kindly see the order. Considering the rival contents of the party, this court on perusal of the copy of the sale deed finds the sale deed has clear disclosure with regard to the sale of extent of land 3.5
yes.
decimal and the same time. The sale deed also disclosed the sale of land in length and breadth of 16 to 116. This court also perused the decision discussions of the consolidation office, appellate authority, as well as the revisional authority, and find all the forums has no hesitation disclosing the above. For Hon'Ble
on denial disclosure involving the sale of area of 3.5 decimal of the land with further disclosure with regard to the length and breadth of so and so. This court finds there is a practical difficulty in disclosure of the property sold and for intention involved in the selling. Correction does not come within the domain of consolidation authority. This court in the above circumstances find the consolidation officer remain unjustified in directing the preparation of map and record of right. Taking into account of the material available in record, while information has no specific outcome for the conclusion in the sale deed remaining outside domain of the consolidation officer, the consolidation officer should have left the matter for undertaking appropriate recourse to both the parties by dismissing the section 9 proceeding. This court here finds all three forums have failed to appreciate the legal aspects and committed irregularities. In the circumstances, this court, while interfering the regional order on the same premises, also in part section 9 order as a consequence, also in appeal as well as set aside all. Thus, while dismissing the section 9 proceeding, an impractical claim involved therein for such discrepancy in the sale deed, this court directs for maintenance of record of right and a map in position prior to initiation of the section 9 proceeding. Parties have, however, liberty, if so advised, may attempt for the correction and amendment of the sale deed.
That liberty is given. What is it?
No,
And so far, section 9 is concerned, Lord Mayor, can be seen.
Lord, what has happened is this, my lord, while preparing the map, instead of 16 links into 160 links, the map has been prepared at 20 links into 160 links.
The extra land which is not sold is included. That's what you are saying.
That needs
But
to be
that
corrected.
liberty is granted to you. You can go and
The other liberty, the suit is bad. I cannot go in for once a consolidation operation is there. Hence, section 9 is the only remedy. And it has been vindicated by the consolidation authority. It has been upheld by the appellate authority. The revisional authority has set aside the order. Now the High Court has set aside everything and asked me to find what other remedy is available to me in law. It has to go back to the revisional authority.
shall I give him liberty now? Express liberty.
The question is, my lord, why I am submitting? The state is the competent authority to say.
Now, what is the remedy left for him? Section, a fresh section 9.
Yes.
Fresh section 9.
And there is an appeal, there is a revision likewise. Because your lordship there, a suit was also pending, is also pending.
No, suit was only for injunction.
Yes,
that has been, and there he has clearly admitted it is my purchased land is 20 links into 160 links. He has admitted there.
In this proceeding, who has initiated section 9?
Section 9, yes.
I have initiated. And that was
Review cannot be as act as an appeal.
No, that's right, but the problem is he has initiated section 9 and he has undergone the rigors of section 9, appeal, revision, writ and all. Now again sending him back for section 9 once again to start with.
Only
It's very
nothing more.
the same relief he was asking in the initial proceeding.
And
Section 9, why for he has filed the section 9 application? Relief is same.
Objection once filed, that has been allowed.
That has to be decided this way or that way.
Appeal.
Again
That
sending
is
him
an
back
appeal
to
position.
section 9 is again, rigmarole.
36 application has been allowed in his favor. Had it been rejected, then the consequence will follow.
Yes.
And if you will not avail that section 9,
the revisional order.
This is the very impractical.
Only the revisional order is requires to be satisfied.
But the only problem which I am facing now is how a review is maintainable.
Review is maintainable.
You can challenge that order.
On this short question, that this is an error apparent on the record where only the revisional order is challenged and he sets aside the entire position.
No, he says that all the court has gone wrong.
No,
this is he was see the court was exercising writ jurisdiction.
Writ jurisdiction.
Yes.
My lord,
I can understand if you restrict to appeal. I can understand that in a writ jurisdiction, if it is found that all the orders are wrong, set aside. I can understand. Had it been an appeal, you have to confine your order to that.
No,
it is a writ petition.
Point is this, my lord. In review, the order, if there is an error apparent on the face of the record, a review is maintainable. The error apparent on the face of the record is this, my lords. that he has set aside a proceeding under section 9 saying that it is not maintainable and remitted me back to the very section 9 proceedings again.
Oh,
This
that-
is the
That is
error
not merit. Again, you
apparent
can, you can take it to the right forum to, what is it?
No, error in section 9 only. He admits that.
So therefore, it's completely wrong order, according to you.
Absolutely.
And then you have to go to the right remedy, not review.
No, review is, this is the error apparent on the face of the record. While asking me to avail the remedy available in law,
It is not error apparent on record, it is a wrong order. It's completely wrong order.
it's an error.
And remedy is something else.
Error apparent on the face of
No,
the
it's
record.
not apparent error. Apparent error, it is a wrong order. Absolutely wrong order. I agree with you, 100%.
Once your lordship agrees with me and I am before your lordship.
It cannot be reviewed.
2022.
That's the whole difficulty I'm facing. Otherwise, I would have done it.
Well,
Why not? In the revisional jurisdiction, can I interfere in the
Your
Senate?
lordship may keep it to another date, my lords. Let
Keep it.
me try and persuade your lordship to bring it.
There is a difference between a wrong order and a apparent.
Now, today I've been able
error.
to convince your lordship that it's a wrong order. Give me another opportunity, I will bring it with
You have sufficiently convinced me it is wrong order.
Sorry, my lord.
You have sufficiently convinced me that it is a wrong order. So therefore, the remedy is something else.
So, my lords, if I can bring it within that.
I think you piece your case a little higher than you are supposed not.
That, my lords, is not within the reach of people here in Orissa.
So let's see, had it been an appeal proceeding, and if this order would have been passed, I think you could have maintained a review petition. But it is a writ jurisdiction, and writ, the court says that all the orders are wrong, I am quashing it. Then the remedy is somewhere else, not review.
True, my lords,
I'll just let him.
Your lordship may keep it to 2 days, next week any day.
Next week.
Next week any
Put a
day.
week
Let me try and make an endeavor
Yes.
to persuade your lordship to bring it within
Otherwise,
the purview of
otherwise
review.
the remedies are there, you can very well withdraw and go.
My lords, that I don't think my client would be in a position to avail that remedy.
Okay, we'll see. Yes. Yes.
And more particularly, your lordship can appreciate that better, having seen the people who were availing such remedies.
Morning you mentioned it. So how much cost you will pay? Elder brother? Who's?
In this case, last occasion.
Okay. No, there is a bereavement in the family. Okay, and the bereavement, huh? Got it, urgent. Okay. Okay. Entry mode to cut. Yes.
69.
The petitioner, is challenging the order of cognizance and under section 417, 420, 30 prices. My main contention, your lordship, is that this is purely a civil dispute and it has been given a color of a criminal. Fact is, lordships, the FIR was lodged. The charge sheet was submitted as mistake of fact and law. And then after that, the protest petition is filed pursuant to which cognizance was taken. I'll just point to one statement.
You are against the cognizance order.
Lordships.
Yes.
Lordship, we turn to page 34.
3-4. Yes.
I'll just point one statement. Your lordship will get the clear idea.
Yes. 34. Yes, I'm there. Geeta Mohanty.
Lordships.
Yes.
She's the wife of the complaint. I'm placing your lordships. About 15 years back, two staffs of my husband's office proposed to sell their land, and I advised my husband to register the land in my name. But he replied me to register the land in his younger brother Susanta Mahapatra's name and my name equally. Within 1 week from that day, one day my husband advised me to prepare food for so and so. On that day, I had not been to the registration office, as because Susanta Mahapatra had not been to the registration office for registration of the land. When my husband returned to home on that day, he intimated me that in absence of the parties, the whole land registered in the name of Sanghamitra Panda, wife of Susanta Mahapatra. The seller of those land demanded for their money, and my husband paid the purchase amount of rupees 80,000. Your Lordships, to them for my account. My husband intimated me that his younger brother Sushant Mahapatra will pay the purchase amount and get the property. I do not know what happened after that. Your Lordship, may kindly turn to the next page 36.
Yes.
Placing your Lordships. In the year 2001, 2002.
Ajit Kumar Acharya.
Lordships.
Yes.
In the year 2001, 2002, accused Sushanta approached the complainant to look a land for him to purchase it. Then the complainant selected a land and intimated his brother, accused Sushanta, to come to the sub-registrar office for registration. The complainant asked the accused Sushanta to purchase the land jointly in his wife's name and in the name of Sanghamitra of the accused Sanghamitra, wife of accused Sushanta. On the date of registration, as per the request of the complainant, I went to the registration office to help him and his nephew. Himanshu attended the registration office, but till 3 p.m., accused Sushanta had not been for the registration. The seller of the land were present at the sub-registrar office, but neither Sushanta nor his wife were present. Then I came to know that the whole land of 20 hands were registered in the name of accused Sanghamitra, wife of Asu. So it is completely civil in nature, Your Lordships. The fact remains that the purchase of land was in the year 2001-2002.
Yes.
Lordships. The FIR
Who is appearing?
The FIR was lodged in the year 2019. That is well after about a decade. Your Lordship will see the complaint case, which is at flag, which is at Annex 1. It is of the year 2019. So when the land was purchased, it's a belated claim. Even if it is suit, it's a belated claim. And they have to get the land was purchased in my wife's name, in the name of petition number 2. I have a right to purchase it. Just because you pointed out a land to me doesn't mean it has to. I have to give you the patch of land. It's a simple.
Yes, yes, sir. What are the other allegations?
That is the allegations. Other than that, nothing else. He alleges that he has paid, but no proof has been brought forth. That is the reason, mistake of fact, mistake of law. Touch it, Your Lordships.
Yes. Yes, sir.
The main intention of initially the accused person's intention to cheat the complainant, my lord. On the inception of the complaint petition, my lord, on the promise of accused number 1 to purchase spend the money.
Show me any evidence that you have paid the money?
Yes, my lord. There is a check issued on the name of vendor, my lord. There are 2 checks, 40,000, my lord, in the name of vendor, my lord.
1,05,000.
1 lakh other expenses, my lord. Main land value 80,000, my lord. It also issued
where is the check? Where have you said that?
Check.
Yes. IOB check number 3 lakhs. Advance amount of 3 lakhs in the shape of cash of rupees, and other 2 lakhs in the shape of check. 2 lakhs you have given check.
He has paid it to the vendor. It has nothing to do with me. It may be with regard to any other property also, or for a loan.
And that is a subsequent development, my lord. When he spent 1,05,000 towards the land value and other expenses, he repeatedly demanded his money returned back, my lord, from accused number 1, my lord. But he didn't return, my lord. On the repeated request, he accused number 1 suggested
any civil case is pending.
No, my lord. No civil cases.
Instead of filing a suit for specific performance or whatever right to Your Lordship, because here, admittedly, he has not paid.
How much you have taken? Forget about the technical.
Taken. Yes,
He has taken, my lord.
I purchased the property.
I am sending it to mediation. You might have taken some money. It looks like.
Your Lordship.
I'll send it to mediation. You are shielding behind some technical.
Provision also clearly says.
Settle the dispute, you won't get anything. If you settle the dispute, something you may pay. You can't secure a conviction also. If this is the kind of evidence you have.
No, I
have already stated the proceedings.
Yes, my lord.
Try in a mediation. If you can get something, it's better. Otherwise, you have not initiated any civil proceeding.
Yes.
Neither for recovery nor for specific performance, nothing is there.
I have a document, my lord.
You keep document time barred. Suits are time barred. Now you can't do it. Anything. So whatever you will get
The
in
whole,
this proceeding.
the whole act, my lord, explained, my lord. On the promise of action number 1, complainant spent the money, my lord. Otherwise,
weak
he would not be, he would not spend, my lord.
Very weak evidence. You may be correct because you have only
Till now, I have
oral evidence of 2 witnesses. What will money transaction?
Every mediation in Berhampur, both parties are in Berhampur. I think my learned
Berhampur.
will agree.
The matter is heard partly and it transferred to the hearing that the dispute is essentially a civil in nature, and the parties are willing to explore the possibility of a settlement. Hence, the matter is negated to District Mediation Center, Berhampur. The coordinator will direct so and so, awaiting the mediation report. Please the matter so and so. The interim order passed earlier shall continue till further orders. Till further order. Yes.
My lord, what is the order? I cannot heard, my lord.
The district
I have
mediation center.
send the matter to mediation, Berhampur mediation.
Yes.
You try.
Okay.
If something happens, otherwise.
Till then proceed.
70.
Okay.
My lord, I prefer passover, my lords.
Passover.
The lordship passed the order on 29 January 2025, directing the concerned IAC to issue notice to the complainant number 2. We have sent letter to the IAC, but till date no instruction.
Pursuant to the order dated 29/1/2025, the notice on the opposite party number 2 was to be served through the IAC Info City police station. However, no instruction has been received by the State Council. 6/9 adjourned. Yes.
71.
Interim order to continue. 71.
70, I am giving a adjournment. Yes.
71.
My lord, here I have objection, my lord. Because of pendence of this case, my lord, they have cited the order, my lord, that this case is pending in another application. They are enjoying this, my lord, interim order in a bail application. In the bail application, lordship kindly see the last order. Your lordship find the intention of the council appearing in this case.
You are appearing for opposite party.
I am for the opposite party number 2, my lord.
Yes.
It is an order challenging the order of Cognisance. I am the, my lord, lady. They are, my lord, get the interim order in that case and citing this case is pending, my lord, and interim order is continuing in their one.
Yes. There is opposition. What to do? There is no interim order.
No, here no interim order. That is the problem, my lord. Here no interim order. But they have citing that this case is pending in another bail application. Lordship kindly see the last order I have checked today, my lord. That's why I could not produce, my lord, just now.
Yes.
That is ABLAPL number 11532 of 24. They are, my lord.
We have that order.
No, my lord. Just, my lord, mobile, my lord, have checked. My lord, 3 application filed, but they are not cited, my lord. In the certificate, your lordship kindly see the matter out of this petition was not there, my lord. That is the problem.
No, that certification they have not given. Where are they getting advantage of this pendency case?
My lord, in the PS case, my lord, I am checking, and thereafter I find that 3 cases is pending, my lord, including this.
How many you have? You have to disclose those things. Learned counsel for the petitioner seeks an adjournment on the personal ground. Mr. Subhagya Das, learned counsel for the opposite party, submits that the petitioner has earlier also approached to this court.
In bail application number 4606
for various relief, but those proceedings are not disclosed in the present petition. Learned counsel for the petitioner is to file an affidavit regarding the same. This is the matter. Yes.
72.
The marriage between petitioner with opposite party number 2 was dissolved by decree of divorce, and notice has already been issued.
Service moving. Service is sufficient, sir. Yes.
I filed this criminal miscase for passing of the affair under Annexure 1,
Yes.
TGR case.
Hmm.
Since marriage has dissolved since last 2023, I'm entitled the petition under section 13B of the Hindu Marriage Act filed by
That's right, but merely marriage is dissolved doesn't mean that criminal case will be
dissolved under Annexure 3.
That's right. Have you entered into a settlement?
Yes.
Where is that settlement? Show me.
Settlement, that is petition. That is Annexure 2. That is petition itself is the settlement and both the parties have signed it. And petition, the petitioner one shall pay rupees 2 lakhs for alimony of the petitioner number 2 and her daughter 2 lakhs, 1 lakhs towards permanent alimony, petitioner 2 and 1 lakh towards permanent maintenance, fooding, clothing, medicine, educational expenses. Page 40. Expenditure of her daughter, 5 installment on 21/12/2000. Petitioner has paid 40,000 in shape of cash in favor of petitioner at the time of filing of this case. And thereafter, after fulfill all the conditions, both the parties have signed
page 41. Page 41, paragraph 18. Paragraph 8. Sir, service through.
As per agreement, both the undertake to withdraw all the cases.
You are not reading the relevant part. You are reading here and there. Service through IU. Service through IU. Sir, okay. Stay, huh? Stay.
73.
May I be pleased, my lord? My lord, the real conducting lawyer of this case, my lord, he has the file and he is moving to Bhubaneswar for the health condition of his wife is next week, my lord.
Time, my lord. Speaking in urgent. Yes.
75.
Yes.
That matter the elopement on marriage and they're staying together. Last time, Lordship was directed twice for as to the status of the investigation. So now the matter is rest at my lord's the status of the investigation because the offence is under section 363, but the affair was registered.
Yes. Have you got any?
My lord? Yes, my lord. 376 POXO has been turned down.
Okay.
373, 376, 506, 6 POXO turned down.
Charge sheet filed.
My lord, this is the I have the
Check it
copy
out.
of it.
Charge sheet filed now.
But not 164 statement. 164 statement when she does not disclose that any physical relation. Otherwise, against the will, so 376 is an attempt of the police investigating agency to carve on the prosecution when the petitioner prosecuted the 164 statement.
Have you read the 164?
My lord. There is, in that case, my lord,
Instruction has come, you'll also kindly have that.
Hmm?
Last page. Now he is not residing in the present petitioner's house or the other house. He is working
No,
labor in.
he has said that they are married and everything.
Right.
And ଏହା ପରେ ମୋ ବାପା ବାହାଘରର 5 ମାସ ପରେ ଅନ୍ୟ ଲୋକଙ୍କ କଥାରେ ପଡି ମୋ ସ୍ୱାମୀ ଶ୍ୱଶୁରଙ୍କ ନାଁରେ ଏକ ମିଛ କେସ୍ କରିଛନ୍ତି। ମୁଁ ମରିଯାଇଛି ବୋଲି ସୁଧି ବି କରିଛନ୍ତି ମୋ ନାଁରେ। This is the parents of the girl. This is the
instruction from the IAC madam. From the last page.
ତେଣୁ ମୁଁ ମୋ ମା ବାପାଙ୍କ ଘରକୁ ଯିବା ନାହିଁ କାରଣରୁ ସେଠାରେ ଜୀବନକୁ ବିପଦ ଅଛି।
There is a instruction my lord from the police. Last page. I have also flag marked there. Now he is not residing in a in-law's house. He is working as a laborer in Paradip somewhere else. I have flag marked there. Kindly have flag. Probably now he drove.
The victim was physically present before lordship.
No.
Yes.
Instruction down.
Oh, she is not neither staying in the parental house.
Yes.
Obviously, parental house, no question.
Thereafter,
and nor in the in-laws house. He is working somewhere else. What to do? He's not getting support from either side.
Whether he is residing with the boy or not, that is instruction.
That she was physically presented and said that I was staying.
But who is the informant here?
Uncle, my lord.
Uncle.
He is also present. My lord.
What to do? Oh, the father and mother are not supporting. His uncle.
Uncle.
The final result of the arbitration proceeding didn't set the criminal law into motion for the redressal of the offense of forgery and production of forgery document in furtherance of the criminal conspiracy committed by all accused persons who are involved in the same transaction of forgery and production of the false documents, finally succeeded in giving false evidence in order to evade Hughes' claim of company in the arbitration proceeding. As such, the culpability of the alleged offense is proved from the perusal of the document number 1 and 2, and the evidences produced before the arbitral tribunal on the said document are also filed and relied upon. But the tribunal didn't whisper anything about it. Tribunal has awarded the contract because he didn't complete it and it was partly done.
You are clean.
Right.
You are clean.
Their claim has been allowed.
Their claim. Okay.
Their claim has been allowed. Paragraph 5.
Then award is in their favor.
Yes, majority of the award. Three members were there. 2 members gave in favor, 1 member against.
Yes.
That is all in paragraph 5.
Yes.
Be that as it may, the tribunal lastly pronounces majority finding that award dated 21/2/2017, wherein also the issue of forgery of document 2 by the accused company was reiterated. It was held that accused number 1 company in collusion with other accused persons in furtherance of the criminal conspiracy hashed out by all the accused persons made the forgery of the document number 2, produced the same before the tribunal to frustrate cause wrong is there. Added to that, he has also mentioned about it. Prayer is on the basis of that there is a criminal conspiracy and all that. Therefore, Hon'Ble Court pleased to take cognizance of the alleged offense. The documents he has relied upon. So kindly turn to the evidence. Page 31, the pre-charge evidence. At page 32, annexure 2. I'll just take your access to page 56.
What is the disputed amount, by the way? Award amount.
The award amount already paid. Entire amount paid.
Who is appearing? You
So I'll show the finding warrant.
You are appearing for.
The kindly look at page 56.
56.
Yes.
Yes.
105 question mark in cross examination.
Yes. Signature appearing.
The documents downloaded
56 you are reading?
Yes, 56, my lord.
That's a document downloaded from the website.
Of Ministry of Corporate Affairs do not bear the name of Sam Jindal as director or signatory details.
Yes.
It is his statement, my lord. The complaint statement, the lordship looks at.
Yes.
Page 32, his statement started.
Wait, which document you are talking about?
So this is
The offending document. Which are the offending document?
Offending documents are the documents filed, my lord, at page 26.
20? The
26.
same document is downloaded
Yes.
from the official website.
Yes, yes, my lord.
Same document.
Yes, yes.
No, not same. They are the corporate, the name of the company.
So the director name may not be there. That's
ROC, that is the list. That was
the
downloaded.
ROC document downloaded, their signature may not be there. That's the different story. Which is the offending document?
Sir, these are the documents, do not show anything.
Huh.
The documents relied upon do not disclose anything about it.
Page 20. No, they say that during the arbitration proceeding, you have taken advantage of certain documents.
Yes.
Manipulated documents. And in the arbitration proceeding also, they have reiterated those things.
Yes, yes.
Document number 2, which is the that document number
Look at page 28, my lord.
28? 28, okay.
It also.
Yes.
No, but they can.
28, yes. Yes.
Page 28, my lord.
Yes.
Annexure 12.
Yes.
Pages 1 to 7 is printout of information available on website of Ministry of Corporate Affairs, Government of India. There's a Jindal India Thermal Power Limited and TCE. Pages 8 to 20 are the documents filed with the complainant company, accused number 1 company in the arbitration. Mrs. Quartz versus so and so. Page 21 to 24 are downloaded from the internet on the dates shown therein.
Yes.
I have personally downloaded the said documents from the said website. But with reference to this, the answer is at page page 56.
This is the only document, offending document.
Yes, yes.
This is the only document.
This is the only document which refers to connect me, my lord. Accused number 6.
No, 120B is also there. If any other document is also there, then yes.
So here, there is no offending document, right? Don't.
So, but while learned senior is appearing, we are appearing for accused persons in same case. So since I am little acquainted with the facts, just to supplement my learned senior.
Yes.
So what is the allegation? In the complaint itself, the allegation was before the arbitral tribunal, one document number 1, which is a specification with regard to ice stack. Ice stack is an ice pond. He was a contractor. For the purpose of construction of that ice stack, specification was supplied by the company principal Jindal to the contractor. That is document number 1. So during arbitral proceeding, he had submitted that document number 1 exhibited before the arbitral tribunal. Now during the arbitral tribunal proceeding was going on, on behalf of the company, one document number 2, a specification bearing contrary to particulars in the document number 1 was exhibited. Am I clear?
Yes, I understood it.
That document number 2
is
he complains to be a
stated to be a false.
So that
Yes.
is the, as your lordship is saying,
Yes.
that is the document disputed.
Where is that document?
But those finding those my lord is asking about those 2 documents.
Show me that document.
Those
Yes.
documents will be shown to you.
Yes.
Those documents immediately may not be available with us. Will be shown to us.
That is the bone of contention.
That's not the. Let me carry your lordship to the point involved.
Yes.
But those 2 document number 2 are objected to him by him. He said that it's a false document. But
In the arbitration proceeding also the same stand taken by them.
he took a stand
Yes.
and filed application to initiate 340 application to refer the matter to the court. Then that application was rejected by the arbitral
Rejected.
tribunal.
Thereafter, they
Now
filed.
rejected by the arbitral tribunal. In the hour, there was no finding that that document is a fraudulent. In the hour, that document was dealt with, but it was forced. There was no such finding. But what he did, after the hour was passed, he filed 3 complaint cases on different subjects, and now out of those 3,
2 have been discharged. Out of the arbitration
Yes.
proceeding itself, he filed 3 complaint cases. 2 have been discharged. Now this third one, his allegation is that since you relied upon a forged document, you have
Document number 2.
Yes,
Yes.
these are the offences against you. Now, during trial, after the cognizance was taken, that very disputed document number 2, he writes in the complaint petition that the arbitral tribunal has given a finding that this is a forged document. And on that basis, he has lodged this complaint, which is error apparent.
No, there is no finding.
No finding.
So page 22, if Lordship can see.
He's 22. Yes. That he says that document 2 is reiterated in the arbitration proceeding. 22, yes.
Sir, as the cross against the CW went through page 280, question number 280, didn't yield any fruitful result. The accused number 1 company was constrained to file document number 2 containing the contrary specification along with application at 26/9/2014. This is the document number 2.
Yes.
As a mark of surprise, the
Document number 2 relating to specification of
relates to specification of as die contract really ran contrary to the earlier field document number 1. So they said document number 1 and 2 are contrary to each other.
That's what I'm saying. Show me that document. Offending.
Here it is, the document is there.
Show me that offending. Where is that? And show me the award. Simple.
Yes,
Not beyond that.
Our kindly see the award,
Yes.
that part of the finding in job.
Come to page 24. Come to page 24. 24 para 5.
Yes, sir.
24 para. Be that agent page. Arbitration tribunal. Read
That tribunal award is there.
Now, they read page 24 para 5.
Do that as it may, London Tribunal lastly pronounces majority finding that para 5
Yes.
Wherein
wherein also the issue of forgery of document 2 by the accused company was reiterated.
Yes.
Reiterated.
Kindly sit down. We are giving that out. Award to the
Give me that award.
This is the award.
If that is the basis,
Yes,
the
yes,
award is
that's
nothing
right.
there.
Kindly see the award. Say, perfect.
Yes. Who is you are appearing for? Show me the award. If the award has it been recognized?
Finish first, let them finish.
Now you show me. This is the one of contents. This is the only issue. You have filed so many things, but this is the real issue. In the award, whether the document number 2 is designated as a false document or not.
Yes.
If that is the basis, you show me if the award has designated it. And have you encased the award?
Yes.
Yes.
Then what else remains?
The Supreme Court also taken note of that.
Yes. Show me the award then. Show me the award and where the document number 2, the offending document is identified by the arbitration tribunal to be a false document. First, show your show the claim statement, reply to the claim statement and award. Yes.
Let me take it in my way, Madam. Then
Yes.
after your lordship.
Yes.
I'll answer your lordship.
Yes.
This issue has been traversed. That judgment has not been filed by them, but they should have filed that judgment. Lordship, may kindly take up this
Which judgment?
on the same issue.
Yes.
Judgment of one coordinate bench manner, judgment dated in a 482 application, seeking quashing of the Cognisance order. Sir, your lordship, may kindly have my counter affidavit. In 2024.
Yes.
They have referred to
Who does
that.
it?
Counter
They have referred to that, but they are curiously manner that judgment has not been annexed.
But that is disclosed. Can I just clarify? Subject to Mr. Palik permits. Subject to Mr. Palik permits.
Yes.
But can I just clarify about that issue? Because we are supposed to clarify. Sir, Mr.
No, this issue is taken note of. Yes.
What did I tell you?
Hmm.
Initially, 482 application was filed by all, seeking quashing of the criminal.
On the same ground.
No, not on the same ground. It's a change circumstance. Now that proceeding was dismissed. They went to Supreme Court. Before Supreme Court, it was also dismissed. It was also dismissed. Now thereafter, pre-charge evidence started. During pre-charge evidence, this sole witness, complainant, made a statement before the tribunal that Sam Jindal is not the director of this company.
Yes, sir. Yes.
That I have not made specific allegation against Sam. These are the two important statements during evidence given before the trial. Once you make a statement that you have not made any specific allegation, there are Jatia and other judgments, Usha Chakravarti, Sibo Sankar Jatia. When you are making a managing director a complaint in a accused in a case, you have to make specific allegation with reference to role played by them. Well settled question. Now he himself is admitting that I have not made any specific allegation against Sam. Keeping that in view, this has been fine. Once you made a statement.
Have you moved to a high court, a trial court?
Before the trial court, the stage has not come.
No, the discharge application.
Pending. You have to move application.
It's not a question of discharge now. It's a question of once you make a statement that no specific allegation you have made, the whole case goes, it should be passed.
I'll give that liberty, you go and move application.
That's a question of discharge.
That's it.
So Supreme Court has clarified.
See, at the stage of cognizance, you came, lost, went up to Supreme Court, gone. One story gone. Second, something comes out.
Yes.
On the pre-summoning evidence stage.
Now, Your Lordship's liberty, kindly consider today why we have approached Your Lordship. The reason being, once Your Lordship may say that that application will be disposed of without recalling any witness. Now he wants to patch up the lacuna by recalling the witness.
That is not allowed so far.
No, sir.
No, that's pending.
That's pending.
No, sir.
So because of the stay order, that's not proceeding.
Okay, good to meet you.
Sir.
Sir, another aspect also you can see. At that time, the award amount was not paid. But the same question arose actually when a discharge application was rejected, and that was also challenged here. Page 92, let's see. The coordinate bench judgment.
I think there is nothing in this case.
No, the page
only thing is hi-fi accused and hi-fi lawyers.
Sir,
Nothing else. Nothing else.
So page 92 kind of.
That's the end of the story. There is nothing in this matter. I can dispose it up within 2 minutes now. I understood it.
So page 92, let's make kind of see. Page 92, Marat. Page 92. Just a minute. Kind of page 92.
That's exactly happening. Nothing is there.
Jodi upon kahideବେ sir jodi upon kahibe that this application of discharge should be decided before the recall application is decided, then we'll go back. Kind of recall hele our defense will go. This application will go.
Why are you apprehending at this stage that will be allowed? That may be rejected also.
Sir, nobody knows. Recall is normally allowed.
Okay, that
Recall is, let them agree that it should be decided before recall.
We should be agree.
Then
He will not agree. Why should he agree?
look at the intention. Look at the intention.
There is what
No, if that the witness, even if it is called, he will reiterate the same thing. How do you know?
Recall, he recalling only for this purpose that he made a statement that I have not made specific allegation against Sam Jindal. He made a statement on the court.
Coordinate bench. There's direct funding of the coordinate bench.
Show me that finding.
So, sir, one point, sir, page 92, let's make kind of see. You also wanted to know about it.
Let Mr. Palik, please hold on. Let him complete.
Page 92.
92. Yes.
This is the finding of this honorable court at another bench in the other connected complaint case.
Yes.
Page 92.
Yes, sir. Yes.
As already stated, I got it last sentence.
92. Yeah, I'm there.
Last two lines. 92.
Yes.
As already stated, the award passed by the arbitral proceeding has already been attained its finality.
Yes.
After being carried to the Honorable Apex Court, and as directed by the Honorable Apex Court, the entire award amount has already been paid. The complainant company and the executing court has noted its full and final satisfaction of the said award in closing the execution proceeding. The documents which are said to have been forged and fabricated, also any other document in connection with the said case, have not been placed by the complainant company at the pre-charge stage to take note of any of those, or even the copy of the same which was with the complainant company. Simple version of the managing director of the complaint company cannot make out a prima facie case of forgery, fabrication of record. The correspondences made of the complaint company do not reveal any specific role played by those named accused persons who are said to have been in connivance with each other for the purpose. The bank guarantee has been handed over to the accused company for performance of the contract. No such document in any way hinting out the conspiracy of alleged to have hashed out by the accused persons have been laid in evidence. Having laid the evidence as above at the pre-charge stage, the complaint company has expressed note to lead any further evidence, not to lead any further evidence at that stage. Thus, with all such evidence, it was urged before the court to proceed against such accused person by framing charge. Then kindly turn to the provision of section 241(51)(1) was quoted. I'm reading it, Miller. Then page 37. Court has also taken note of accused number 4. Same person actually. Accused number 481. So in that case, the Sham Jindal was accused number 4. Am I clear, Miller? Sham Jindal was accused number 4. But if your lordship turns to, it is submitted
that pertains to which document?
So that pertains to the document. I'm showing that. It says submitted on behalf of the accused that he is neither a director nor chairman of the accused company.
In
They
that matter.
relied upon annexion 1 consisting of 2 documents. One of his list of directors downloaded from the complaint from the website of Ministry of Corporate Affairs, list of board of directors obtained from the JCPTL. Both the documents prove that accused number 4 is not there as one of the director or member of the board of directors. But from the case record, it ascertained after cognizance was taken, summons were issued the accused persons. Accused number 4 has been appeared in court through his advocate by filing a vakalatnama.
Yes.
That, so kindly look at page 97.
97. Yes.
Correction of final.
No, anyway, in that case, you have been exonerated.
Supreme Court. It's not the Supreme Court.
Yes.
The Supreme Court also declined to interfere at page 100.
In that case, you have been exonerated.
Two cases. There,
in the other case,
what I beg to submit is one contract. He is whether a director or not a director, he is the same person. If in one allegation, complaint case was out of the same transaction between the parties, but maybe different documents are there. But I cannot change my status as director or chairman. If I am neither a
yes,
director,
there you have it. There you have.
Am I clear, Maharaj?
Understand.
My case is here.
3 cases were initiated.
I am in no way connected to the
pertaining to
company.
3 documents. 2 cases were quashed. Why you saying that you have nothing to do with
Nothing to do with the company.
So that has become final.
Sir, what I beg to submit, Maharaj, if I am no
Therefore,
way
he
connected
says
to
that
the
at
company.
least he should be out. That's what he says.
That is exactly.
But where do you want to take this? But you tell me, where do you want to take this matter?
That finding has been rendered in a totally different ICC case where the allegations are different. Here the allegations are different. And it was these very allegations. Kindly allow me, sir.
But the finding is he's not
the issue here. These findings stand. Lots of kindly pick up my counter affidavit in filing 2698 for 20. This is what they're avoiding to say before they launch. Page 49. Straight away, madam.
Yes.
One arbitration.
Also in this regard, pertaining to the involvement of Mr. Shyam Sundar Chinda, this court's attention is drawn to the submissions made by the learned counsel for the complainant company, whereby he submits that Mr. Shyam Sundar Chinda, in the vakalatnama filed by him, before the learned SDGM Sanitarian ID case number 74. This case is different. This was never-
don't have any specific allegation. Must pay to the case.
No, see, merely because in the Wakalatnama he has written chairman doesn't mean that he'll be chairman. If there is a judicial finding in two cases.
This is also a judicial finding of the High Court when we proceed.
So that was before the evidence.
For the evidence. See, the ICC, 1CC is different. The sections are different. 74, ICC number 57 and ICC number 44 has referred to himself as chairman of JTPL. Furthermore, he has referred to himself as chairman of the said company even in the application under section 205 of CRPC filed before the learned SDGM Talcher in 1CC case number 74 of 2017, seeking dispensation
Now, it election will show election.
personal appearance during trial. Apart from this, it is also sufficient that Mr. Shyam Sundar Jindal in an attempt to draw
That
attention
hasn't
to himself
clarified.
and to remain in the
This
shadow
petition
would consistently sign on the documents of Mr. JPPL as number one. When granting approvals or making decisions, the very fact that there has been a contradictory stand taken on behalf of Mr. Shyam Sundar Jindal before the court below while filing Wakalatnama and application wherein is clearly written the word chairman, Mr. JTPL, next to his name, and the contrary stand taken before the court that he is not a chairman, director, employee or shareholder in JTPL casts doubt about the truthfulness and veracity of the submissions, of his submissions, as well as casts a doubt on his role in the company. The same requires proper determination.
Yes.
From otherwise, the fact that such contrary stand has been taken before the court of law makes the same dubious and necessitates examination of the same. So this is the finding of the coordinate bench. How can we malus?
In this case.
Yes. And here the allegations are different. Forgery of documents.
But by the way, where do you want to take this case? You got the award.
Huh?
You got the award. You have encased the award also.
Award is there.
What will you do?
That's the choice of the that is the choice of the client. It's not my choice. The choice of the client. My submission before your lordship is that that judgment in which the coordinate bench discharged the petitioner in the revision application, along the discharge petition and which was confirmed in the Supreme Court, that arises out of 1CC 33. I'll again take your lordships to page 24 of this of my counter, the judgment. Here you lordship clearly see the difference, distinction.
33,
The company, this ICC 160 case number 33 of 2017.
Where are you reading?
Page 24.
24. Of your counter. Yes.
This is the judgment. The coordinate in my favor, which gets confirmed in the Supreme Court. Upholding the order of cognizance and directing for the trial to there's another order of another coordinate bench of your lordships, which directs the trial to be completed in 8 months. There, my lords, even the company's lawyers were heard. Counsel for the company were heard. I'll show you a lordship that order.
Yes.
The complainant company has alleged commission of offences under section 147, 447,
containing the opposite party here and
408, 409, 420, 426, 341, 409 and 120B of the IPC read with 34 IPC contending that the opposite party is therein, including the present petitioner JTPL in criminal miscase number 2039 of 2017 and SMSMMP in criminal miscase number 343 of 2018 have misappropriated the company's property that was lying in the work site of the Dowry power plant for their own individual benefit, while colluding, conniving and acting in concerted manner in further a criminal conspiracy to illegally oust the complaining company from the work site for their own gratification. The opposite parties have surreptitiously entered the work site at Dowry power plant and taken over the work of the complaining company in a malified manner behind the complaining company's back. The opposite parties have also forced the complaining company to sell its materials on the work site to Messrs. SMPL on a much lower rate than acceptable, out of which also the full payment was never realized, despite multiple reminders and requests, as seen The opposite parties have dishonestly misappropriated the complainant's company's movable property and have cheated the complaining company while also committing criminal breach of trust.
I understand. 33. That is 33 of 2017.
Here,
What is 74?
74 next, page 25.
What is it?
The complainant company has alleged commission of offences under section 191, 192, 193, 196, 463, 465, 468, 471. 120B, 420, 406, totally different section. And totally different offences committed. Alleged, of course, at this stage. Section 34 IPC containing.
No, these are the false document.
Mala. This is for this.
Arbitration tribunal pays the reliance on the said evidence and the misled the tribunal despite knowing the same to be false and false document, including the label book, fraudulent so and so.
So this is Mala, and there.
This is regarding documents.
Mala, and there the finding of the court has quoted Mala copiously
And
quoted.
come to page 26.
26.
Yeah.
Right.
Top.
Company submission that the defendant number 2.
This is the document.
Yes, specification of the contract was altered. Was said to have inadvertently filed the opposite party despite the fact that defendant number 1 was admittedly treated as undisputed document. So therefore, my lord, that was something which happened before the arbitration proceeding. This is something which is in the midst of arbitration proceedings. There the cheating and under the allegation that totally the range was different.
No, this document number 2 is used in arbitration proceeding. That's your case.
Filed in the arbitration proceeding.
Yes.
They come up. Here, my lord, again the
consulting agencies. Who is unaccused?
Page 42. The honorable judge has copiously quoted matters.
And what is 57 now? Let us see. 57. 57, page 27.
57.
Correction of final bill.
The company has alleged that the commission of offences of.
So these two cases are dropped. 57 and 33 is dropped. And this 56 is going on. 74 is going on.
74.
This is 74.
Here, the page 44, 42, I'll start from page 42. In the present case, para 14. In the present case, the main issue underlines 3 of the 4 impugned criminal complaints. That is ICC 333, ICC 34, 74.
And then 4 cases were filed. 44 is also there.
44 is there.
4 cases were filed. What happened to 44?
44. There is no
3 cases.
3.
What is this ICC
paragraph 14? Paragraph 14, if you lordship look
No, ICC 44. Just see. Page 28.
Page 28.
Page 28. ICC 44.
That 44 is wrong. That's a wrong typing.
No, not typing.
It must be 74.
No,
74 is also.
First in this case.
First.
I'm sorry.
4 cases.
I'm sorry.
4 cases.
Was passed by the same or not?
But there are 4 cases. Yes.
44 was quashed. Here, my lord.
Page 23.
Here, no, kind.
44 has been quashed at
Para 20.
Page 53.
I think you have to file a convenience volume. You are referring to this that will not happen. I don't think this. The only problem with them is they have burnt finger by approaching this court inviting some findings. Otherwise, you don't have a case.
No, that is.
That's the whole difficulty with.
Can explain that the finding given by the honorable.
That finding before trial.
There was no evidence.
There was no evidence at that time.
See, then the trial court has to look into it. Why should I in 482 I entertain this?
Explain everything. Lordship will highly.
So far as my case,
that is the only problem with you. The problem is you have already burned your finger by inviting findings against you at the cognizance stage. And now some evidence has come which is supporting you. Then the trial court will look into it. Why should a 482 proceeding?
So sir, here I am no way concerned.
Now,
Merely because they have moved an application for recalling that witness.
now they have passed
Feedback has delivered the judgment. Second 482 application in case of change of circumstances is made. Very.
Am I saying that it's not maintainable? But why should I enter that? That's what I said.
There is no dispute about it.
It is maintainable, therefore I'm hearing it. Otherwise I would have disputed it up.
She will take it up, we'll also.
May I suggest one thing? You move an application in the trial court. I will not pass any order. I will not pass any order here. Simply urgent, get an order from there.
Sir, SETI discharge.
You move application.
Sir, 6 part आपण consider करतो. आम्ही company पे आम्ही जो 6
So 6 actually in 2
You
cases.
cannot move application.
6 then.
Okay, but insofar as your case is concerned, you move, you move application before trial court, let the trial court consider it.
6 is concerned. Why it is held that I am no way connected with him.
No.
I will not dispose it up. I will hold it. Let us have the advantage of the trial court's order on discharge.
ଆମେ ଗୋଟେ convenience compilation ଦେଇଦବୁ ଆପଣ ଶୁଣି ଛାଡ଼ନ୍ତୁ ତାପରେ କରିବେ.
I think that would be a better course.
Definitely will not try to come up with your expectation.
Convenience complaint.
So company may challenge you. But
company I'm appealing. I'll do that.
so once I have been held to be not
But
connected to
insofar
company.
as
6
Shyam Sundar Jindal is concerned,
Yes.
and also he has some objections.
Page 58, the discharge petition has been annexed.
I know, but I was suggesting that let us invite a order from the trial court
Right.
in discharge petition. It may so happen they may be discharged also.
Take away trial court.
So therefore, you should.
For 6 years also may consider.
I am not disposing it up. I will just give a direction. Let it be disposed up without being influenced by any of them.
We file a convenience comparison. So far as the
Then we will have.
we have a better case before my lords. Accused number 6, your lordship will consider independent of the company. Your lordship will take up some other day.
And meantime, let the discharge application be decided.
That may not be observed right now. Your lordship will pass that order in the next. Let us also come to consider.
But I think that would have been the best course.
We will respect
Best course. That would have been the best course.
Right.
So
Let us take.
So that finding that OP number 6 and action number 6 has no connection was challenged before the Supreme Court.
Virtually, they are inviting you not to sit over the discharge.
No.
Chalo, convenience volume you give. I'll hear. And what I have observed is rightly I have observed then. Otherwise, this matter should not take 5
It's a peculiar case where arbitration case,
There is
somebody
nothing
gives award.
I could have.
Two off-quoted
No,
funds
don't accept
second manors, looking at the conduct of this company, I would plan a Shakespeare manors, Leo of the Luther. Leo of the Luther.
But by the way, what do you want from them? By the way, what do you want from them?
After running from pillar to
You got the award.
Then all
So you got the award. You encase it. What do you want?
charity department.
Hey, what do you want? I just wondering, what do you want from them?
Justice on the fruit of judgment.
More money. That's
So ask them why prosecution for this?
Place it.
I want this for my
Arbitration method of final.
from pillar to post manors.
So what do you want now?
Virtually manor, virtually my
Eight Sir, you have page 57. Can you have a look at page 57? Just a minute, sir. Sir, page 57.
57 approve.
2698.
We'll hear it next week.
Sir, page 57.
57 of your petition.
Yes.
2698.
57. Yes. Yes.
The Supreme Court order.
Supreme Court. I have seen it already.
Yes,
I've seen it. I've seen it.
Yeah, they have specifically mentioned the petitioner already deposited 7.5 crores.
Yes, 34 petition.
17 crores.
Total 17 crores.
Now put your rest of the
That has become final. The award has
Yes.
Supreme Court.
Even alone Supreme Court, I
Justice
was
Bella.
hearing it. Alone my lord, Chief Justice Raji was there. Observe that we'll pass all the proceedings here. But why should all these proceedings remain?
This is, you should put an end to it, all this thing. Just see. You can, yes.
So you're actually posting it in another.
Yes, up to a week or so. Huh? Convenience volume, you just give whatever you want to refer, I'll refer to that only. Give physical copy, I'll do it.
We'll also pay.
Yes. With all judgments and everything.
Right. That's system.
Only relevant part of the document.
Not making one.
Don't file voluminous. Yes. I understood now. I understood. He put it after 2 weeks, 1 week, 2 weeks. Because I've substantially heard it now. So I can dispose it up straight away.
Maybe 24.
24 Mutika.
Nothing.
Not in town.
25th, 26th,
28.
Sir, 28th, I am out of.
26,000.
26.
We have already planned out for those holidays.
26 is
The long holidays.
I think he was in average for the.
Interim or
21st.
21st? 21st. That arrangement. That was.
That arrangement.
Interim arrangement.
Interim arrangement. Yes.
3 o'clock.
I think stop it here.
That's like 3 p.m. 3 p.m.
Yes.
Item 86. The petitioner just for a paltry amount of rupees 500 is suffering for the last 14 years. Lordship will fix up any date and hear the matter.
Let it be there in the board. Tomorrow I can also hear.
Oh, tomorrow also.
All the matters let it be there. Rollover. All matters rollover.
Item 86, on behalf of Mr. Rizvi Mullers, let it add in the weekly list.
Let it be there tomorrow. Yes. Yes, sir.
Ballots,
77.
77 ballots, there are 3 sub-items. My learned friend is in sub-item 1. I am in sub-item 3. But our grounds in these 2 are common. And why I am come before Lordship under section 480? Because of the fact that the complaint itself is not mental. And that is my first thing. And last time, if your Lordship will be pleased to remember, you asked the department, Lordship asked the department how to get over Priyanka Srivastava.
Yes.
The complaint has been filed. Well, section 190 of the CRPC says complaint to a magistrate or chief judicial magistrate. Now the GRCO says how a complaint should contain the name and it should be supported by an affidavit.
Yes.
My lords. Now, my lords, your Lordship will be pleased to see the complaint.
Where is that complaint?
Yes, complaint, my lords.
Yes, I have seen it. Yes.
25,
page 25.
Yes.
Yes.
Complaint, my lords. Wait, more page.
Is there any separate affidavit? No.
No separate affidavit, man. I have given the order sheet also.
How will you?
Yes. Just a minute. Mr. Mahanti, please wait. And you have filed a counter that says that my allegation is self-serving. That also I am saying.
No, we are not on the allegation. We are on the procedural part.
Yes.
Priyanka Srivastava says every complaint should be supported by an affidavit.
Yes. And moreover, my lords, Justice Gawai has reprimanded that in Babu, that judgment I am giving, my lords. Now, nowadays, this observation Supreme Court has made, nowadays the complaints are being filed without any supporting affidavit. Lordship may be pleased to, now since your Lordship is rising, I'll just bring to your Lordship's kind attention to one.
Is there any exception to the cases of 2C cases? No. Priyanka Srivastava is applicable to 2C cases or not? Because these are departmental complaints. Whether in a departmental complaint, the Priyanka Srivastava applies or not, that's the question.
Well, I understand. Under section 200, when the process is being issued, the magistrate, if he is a government servant.
No, the idea of Priyanka Srivastava is personal knowledge.
Yes.
Personal knowledge.
Yes.
If a complainant is filed, Union of India is filing complaint, represented by XYZ officer.
Yes.
Whether Priyanka Srivastava ratio is applicable or not, that's the question.
Yes.
That's the question.
Yes.
Don't,
my lords.
they have to answer that. Have you checked it? That is if Priyanka Srivastava there covered, then your complaint goes straight away. Straight away complaint goes, because just see page if you come to page 25 onwards, page 30 if you see, there is nothing. No affidavit, nothing.
All these cases plus no affidavit.
No affidavit. So now the question is whether in a 2cc case where the Union of India is the complainant, whether an affidavit is required or not. How can you distinguish Priyanka Srivastava in these cases? 5-6 cases are there, let it be there on the board. Tomorrow I'll take it up.
Yes.
A small matter, within 2 minutes it will be over. Give the judgment and tell me.
They have
I
already
think it should be research on this.
They have already filed it.
What is the idea of Priyanka Srivastava? Affidavit to be attached if personal knowledge is there.
Yes.
Because you have to say that these averment which I made, I have personal knowledge.
Yes.
Therefore, an affidavit is required. But in 2cc cases where a Union of India is filing a complaint, personal knowledge of the complainant through whom you have filed is not required. So affidavit may not be required also.
Right.
Did you follow? This is the whole long and short of the matter.
Statute,
Don't go here and there. Tell me tomorrow. Tell me tomorrow.
The statute doesn't make any
difference. No. The idea of the affidavit is that you have to take that idea into consideration. Idea of affidavit is you can't throw in complaint.
Yes.
Because you are imputing something on your personal knowledge. Therefore, an affidavit is required.
Yes.
But in 2cc cases where the Union of India is filing, authorized by this officer, he doesn't have the personal knowledge. On the basis of record, he has done it. In that situation, how will you apply Priyanka Srivastava?
In that situation, my lords, not only Priyanka Srivastava, now also.
Not let us confine to Priyanka Srivastava.
No.
And then merit will.
No, I am not on merit, my lords. With great my humble submission before lordship is, I am not on merit. I am that notification given in 2024, 2008. I am not on that.
Only Priyanka Srivastava.
I am only on. My lords, when my lords may kindly see, when a complaint is being filed, specifying that these offenses have been made by a company or a body corporate or by an individual, he has to specifically state, and it should be supported.
Not like that, sir. Come to page para one of the complaint. Read the beginning.
Yes.
Read the beginning. How it starts. That it is found from the computerized statement.
It is found, yes.
Read the entire complaint. Where is the personal knowledge imputed?
Para 1. He is an officer of the Income Tax Department, Government of India, the Commission of Income Tax, TDS.
Para 1 it starts, it is found from the computerized statement that the SSC deductor had deducted the tax in source. So this is on the basis of the computerized statement.
Yes.
So there is nothing personal knowledge of the complainant. So why should he file an affidavit? You just tell me that part, that's all.
Then
that's all.
Lordship,
Tomorrow.
Now, my lord.
Tomorrow I'll hear it.
Yes.
Tomorrow it will be there. Only to that extent, nothing else.
Yes.
Interim order.
Interim order.